None appears dismissed. Oh, state. What's the delay? There's a delay of 748 days in filing the appeal, which has not been properly executed. The delay application is dismissed consequently. Appeal is petition is appeal is dismissed.
Supplementary list item number 2.
May I please, your lordship?
Item
By the
number
last
2,
order,
before
you
my
must-
learned friend starts submission. Persons to your lordship's order dated 8th of August 2022. I have communicated the fact for filing of affidavit, but they have not yet filed affidavit.
No, you just wanted to know the current status.
Yes, my lord. Current status and to file an affidavit to that effect. My lord, I have
Mr.
issued the letter.
Mahapatra, learned senior standing counsel for SNME department, seeks and is granted 4 more weeks time to file the affidavit in terms of the order dated 8th August 2022. Rejoinder thereto can be filed the next day. 15 December.
Grateful, lordship.
Sorry, item 3.
The order passed by the honorable single judge has been complied with. They have already complied with the order. Completed. Item 3, my lord, we have complied the order.
All right. Counsel for the appellant states that the orders of the single judge has been complied with. The appeal is dismissed as infractious.
Item number 4.
None appears dismissed.
Item number 5.
No instruction. Make up your mind, sir. You want to withdraw or no instruction?
No instruction.
Item number 6.
May I please, my lord? My lord, may I pray sub-item to be taken up first? My lord?
Whatever. Tell us what the matter is. What?
Yes, my lord. Here, what happens, my lord? The petitioner in a suit, right title interest was declared in favor of the petitioner, my lord. Then the state approached before appellate court, that got dismissed, my lord. And I was enjoying the property by constructing sets till that period. In the meantime, in the year 2014, one PIL was filed, my lord. And one PIL, some plot number, khata number were mentioned. And in that khata number, my plot was not coming under that khata number. And in the year 2015, this honorable court directed to carry out all the demolition over the encroached properties, my lord. My lord, in the meantime, they also in a wrongful manner, they evicted me and without proper notice, and they demolished my over the property, for which I preferred writ petition, my lord. And while disposing of the writ petition, the honorable single judge did not come to the finding that I am the encroacher. Not he relied upon, he didn't consider the relevant materials on record, straight away dismissed my petition. Now this is the writ appeal, my lord. And my lord, in the counter, they have admitted this fact, my lord. And my lord, kindly have a glance to their counter. Para 5,
Yes.
internal page 2.
Yes.
May I read, my lord?
Yes.
That it is humbly submitted that MS plot number 2609 under khata number 183, Muja, Talakia, was not involved in writ petition number 2621/14. This is the PIL, my lord. And this MS plot number belongs to me. But after receipt of notice in writ petition number 2621/14, the then Tahsildar appeared in the above noted writ petition before the Honorable Court and has also filed counter affidavit dated 24/9/2014. In counter affidavit, the then Tahsildar stated that except the land involved in the above noted writ petition, khata number 183, plot number 23609, other encroachers, also the land covered under MS khata number 183. My lord, this is their submission, my lord, abhorrence. My lord, kindly have a glance to annexure B at page.
No. What is the relief you're seeking? That's not clear. So your house has been demolished.
My lord, in a wrongful manner, they demolished.
No, 1 minute. I just want to know factually. We'll now come to wrong, right, and all later.
Yes, my lord.
Factually, I want to know
Yes,
your
my
house
lord.
has been demolished.
Yes, my lord.
What has the land is still vacant?
Yes, my lord.
Who's occupying that land now?
My lord, nobody. That land is lying vacant, my lord.
I see.
That is a government land and we have demolished.
Government land?
Yes, my lord. This is what has happened in the earlier writ petition, the petitioner's land was not included. But subsequently, in the second round of litigation, the Honorable on the Tahsildar's affidavit said, whosoever are in unauthorized occupation, they may be evicted. And accordingly, he is one of the unauthorized occupiers. He was in compliance of that order. He was evicted. And that is depicted in the impugned order of the Honorable.
My lord, my submission to my senior friend's submission, my lord. My lord, this plot never belongs to government land, my lord, because I have acquired right title interest through suit, my lord, and I have annexed those. Yes, my lord, in the writ petition, my lord.
No, is that admitted by them?
Yes, my
Was
lord.
government a party?
Yes, my lord. Government is the party, and thereafter they preferred appeal. And my lord, admittedly, in the writ petition,
In your response to their argument about that right decree, what have they said in the counter affidavit?
my lord, nothing they have mentioned.
No, which government in your writ appeal have you said that you attained the right title?
Yes, my lord, in the,
Let's see that one.
my lord, in the writ appeal.
Yeah, let's see where. 3.
My
Para
lord, in
3.
the first page 4
Yeah.
at
Para 3.
page, my lord.
Para 3, madam.
Yes, my lord. My lord,
What have they said in reply to para 3? 1 minute. Let's just see that. No parawise reply.
No, my lord. And rather,
the whole
they have
problem, sir.
admitted.
She's asserting title through a civil
Yes,
suit.
on the basis of a civil suit.
And a decree
That
in their favor. So it's not an encroacher.
That suit judgment is annexed.
Yes, my lord, in the
Right.
writ petition, it was annexed. And writ appeal, which
Where is the decree? Shows the decree.
Yes, my
That
lord.
decree may kind
the
annexed.
writ petition 365
Ah.
at page 23.
Page
23. Sorry, that is my lord appellate order. My lord, kindly have a glance to 21. Mouja Talakia, Khata number 183, plot number 23609, area 0.01 decimal. My lord. The title of the plaintiff over the suit property is
No,
declared.
but what is the relief that you can now be granted? You are still in possession of the land.
No, my lord, they have evicted me in a wrongful manner, my lord.
No. The land is vacant.
Yes, my lord, I want my possession restored.
No. What way have they taken possession? Is there a boundary with a
by
gate?
virtue of the order upon this honorable court in a division bench, in that PIL, all encroachers have been.
No, this is not an encroacher.
That is what your lordship is saying, that he is
I'm
giving a
saying
decree.
that is their case.
That is I'm sorry, I'm very extremely sorry. She is saying that I am not an encroacher. And as I find in the counter affidavit filed by the Tahsildar, this part has not been
Traversed.
properly
But
answered.
factually, I want to know, it's a vacant piece of land. It has a boundary wall, which has a gate, the key of which is with you. Which way is the possession now with the state?
My lord, that land, I have constructed some shades over that land.
After your eviction.
No, my lord, before eviction.
Madam, please try and understand the question I'm asking you. If you
Sorry,
don't
my
know the answer, you say, I don't know.
Sorry, my lord. Sorry, my lord.
Today,
Yes,
that is today, 19th of 22, who is in possession of the land?
My lord, that is lying vacant so far my instruction.
My lord,
is-
may I submit one thing? He might have obtained the decree, there is no traverse, so we are saying like, but record of right still, that is why in the name of the government, that is why they have filed the counter affidavit before the honorable division bench, that there are so many encroachers, including the.
We don't know all that, sir. If you had done a parawise reply, you would have asked to examine this.
Exactly.
In the writ petition, it was dismissed on the first day.
Writ petition.
Huh.
My lord, no, my lord, on the second hearing, it was dismissed without reaching to the conclusion that it is
No, but
an
no
encroachment.
counter was filed in the writ petition. Right. At least in the writ petition copy we have, there is no counter affidavit.
No counter.
No counter.
What was, sir? There is a decree. They went in state, went in appeal dismissed. By a reason, not by default and all, by a full-fledged order.
If decree has been passed declaring her right title,
And the appeal by the state has been
Appeal stat has
dismissed
been
by a
dismissed.
reasoned order.
then she has got a point.
So let it go back to the single
Yes, my
judge.
lord, to examine this fact.
Yeah, you file a para-wise reply to the
Yes.
petition. What the first sub-item, you are not there in that.
First sub-item also same, my lord.
Same,
Same, my lord.
separate decrees.
Yes, my lord.
Or both these writ appeals, put both writ appeals are directed against orders dated 24th April 2015, passed by the learned single judge, dismissing the appellant's writ petition, civil numbers 3465 and 3466 of 2015. Paragraph. In both writ petitions, the action of the state opposite party in evicting the appellants and abolishing their houses was asked to be declared illegal. Paragraph. While dismissing the writ petitions by the impugned orders, the learned single judge referred to an order dated 17 November 2014, passed by the decision of the court of this court in writ petition civil 2621 of 2014, whereby the court has passed its general direction requiring the state to ensure that open quotation encroachments are removed latest by January 2015 without fail, unquote. Although the plots belonging to the present appellants were not specifically, the plots occupied by the present appellants specifically mentioned in writ petition civil 2621 of 2014, the above direction was construed to be a general one for removal of all encroachments. Full stop. Consequent thereto, admittedly, the dwellings of the present appellants on the respective plots were demolished and the appellants were evicted. Paragraph. In each of the writ petitions, the appellant has enclosed as Annexure 1 copies of the judgment passed by the Civil Judge Junior Division Nilagiri in TS number 29 of 2002-1 and TS number 61 of 1995, declaring the right title and interest of the respective appellants in respect of the two plots, the dwellings on which were demolished. Full stop. Further, it appears that the said two decrees which were obtained, which were passed on contest by the state of Orissa, were challenged by the state in appeal. And the appellate court has confirmed. In the first one, is there an appeal? I don't think so.
Yes, my lord, at page 23.
In 3466.
Yes, my lord.
Oh, I see. Were confirmed in appeal, and the appellate order was also enclosed with writ petition. Paragraph. Therefore, the specific case of both that they were not encroachers and had valid title to the plots, respective plots in question through decrees of the civil court. Paragraph. It appears that no counterfeit had been filed by the state in either of the petitions, and both writ petitions were dismissed on the second hearing, solely based on the fact that the division bench of the court, by the order dated 17 November 2014, in writ petition civil 261/14, had ordered removal of encroachments. Paragraph. Even in the present writ appeals, in the counter affidavit filed by the state, since it was not a paravise reply, there is no traverse, TRAVERS, to the averment in both writ appeals regarding passing of the decree by the civil court and its affirmation by the appellate court. Paragraph. Counsel for the appellant states that to the best of her knowledge, the plots remain vacant, although both appellants are out of the plots. So stop, they're still seeking declaration of the action of removal to be illegal and for consequential reliefs. Paragraph. The above facts have not been considered at all by the learned single judge, particularly since no reply was filed by the state. Full stop. This court is of the view that in the absence of a reply, it's not possible, it could not have been possible for the learned single judge to adjudicate writ petitions. Full stop. For the aforementioned reasons, while setting aside the impugned orders dated 24th April 2015, passed by the learned single judge in writ petition civil 3465 and 3466 of 2015, the court restores both writ petitions to the file of the learned single judge, where they will be listed for directions on 21st December 2022. Full stop. The state will file its paravise reply to either both these writ petitions, both the said writ petitions, separately on or before 5th December 2022, and rejoinder thereto will be filed by the writ petitioners on or before 21st December 2022. No further time will be granted for that purpose. The learned single judge is then requested to proceed with the hearing of the writ petitions on merits and endeavor to dispose them off within a period of 6 months thereafter. Till the disposal of the writ petitions, the status quo as of today shall be maintained by both parties.
Obliged, my lord.
Item number 7.
Well, items 7 to 15 all are from a common order has been implemented.
Counsel for the appellant state informs the court that the impugned judgment of the learned single judge has been implemented. In all these appeals has been implemented. We'll stop. Accordingly, the appeals are disposed of.
Supplementary list item 16.
My lord, I have submitted the order of this honorable court, my lord, in an identical issue, my lord.
That he has to approach the appropriate authority.
Appropriate of that.
Nice. All right.
Order is there, my lord. I have submitted.
All right. Same order. All right.
Item number 17.
May it please your lordship. In this matter, the appellant challenges the order under annexure 1 of the single judge, where the respondent number 1 and 2 approach this honorable court in writ petition challenging the order of the mutation proceeding, my lords. My submission is that that order is appellable, my lords, and without preferring the appeal, the petitioners, respondent number 1 and 2, honorable court, saying that they are the actual owner of the land and they should have been made a party to that proceeding, my lords. Well, the fact is that the order was passed in 2008, and after that in 2009 they filed the suit against this appellant and other persons for declaration of right title interest on the plea of adverse possession. And after that in 2012 they are coming to this honorable court and challenging the order of the 2008 passed by the Tahsildar in mutation case, my lords. And that order is appellable, my lords.
Order of the service. You not even filed requisites, sir.
My lord, I am appearing for the respondent number 1 and 2, your lordship.
Oh, you are there. All right.
My lord.
Hmm.
My lord, the fact is that, your lordship, this is an order passed by the Tahsildar. On the face of it, your lordship may kindly see, this is not sustainable. They have appeared for dead persons filing their wakalat namas. And I have never filed a suit claiming my adverse possession. I have claimed for declaration of title. It has nothing to do with the present rate. Your lordship may kindly see page 11. Whether such an order on the face of it is maintainable. That is what the learned honorable single judge has said. Page 11, your lordship. It is a big land racket, your lordship, that is working, and they have how they have procured the orders. Am I permitted to read, my lord?
Yes, yes.
My lord, I am just reading 3 paragraphs quickly. It is contended by the petitioner that the said Purushottam Patra and Natovar Sahu, who are the actual landowners, died on 4/6/93 and 24/9/90, and death was registered under Birth and Death Registration Act on 8/6/93 and 25/9/90, respectively. Death certificate issued by the Annexure 5 and 6, respectively. It is further contended that a racket dealing with the land matters are doing all fraudulent act in connivance with authorities, hence the order need to be quashed. Learned counsel appearing for the opposite part number 4 as well as intervener, however, contended that they have interest over the said land by virtue of their respective rights over the property. The mutation authorities has to give respect to civil court decree and corrected the record as per the said decree in mutation proceeding. There is no dispute regarding proposition of law that civil court decree is to be respected while disposing of the mutation proceeding. However, the authority is to require into who.
So the death certificates were earlier than the.
Yes, your lordship, 14 years before. And the learned, your lordship, the writ is there. The counsel appearing for them, advocate appeared for them. The learned honorable single judge said on the face of it, it is fraud. The paragraph 3rd I am reading. There is no dispute regarding the proposition. They got a civil court decree compromising the matter with their own henchmen. Owners were not parties. We are not.
Not the fact, my lords.
It is a fact. If my honorable court permits, I will place the decree is also annexed. They got a decree making their henchmen as opposite parties. We are not parties. Government is not a party. Real owner is not a party. Now that decree has nothing to do with us because decree binds the parties. Now that decree they produced before the Tahsildar. The Tahsildar being hand in gloves passed an order that let it be mutated when there is no land available for them for mutation also. And your lordship, if further permits, I'll also place a sell deed wherein 27 lakhs stamp duty is due and that document there sell deed itself is impounded. Honorable single judge said there is no dispute regarding proposition of law that civil court decree is to be respected while disposing of the mutation proceeding. However, the authority is to inquire into who are the parties and what is the decree passed by the court as well and whose name has been recorded in record of rights. Appointment number 2 has that the Tahsildar. Appointment number 2 has not taken into consideration the parties in the civil suit recorded Khatadar while allowing the mutation case. However, the counsels are appearing for 2 dead persons who had by practicing fraud on the mutation authorities obtained an order. This said order is an error apparent on the court in view of the death certificate issued much prior to the death of the order. And for this reason, your lordship, finding that it is glaring illegality and fraud, the honorable court has been pleased to set aside the matter and directed that the record is to be maintained.
All right. Yes, what do you say?
My lords, fact of the case is the petitioner, the appellant purchased the land from the recorded owner, my lord. But after purchasing, there are some dispute between them. That's why the appellant filed a civil suit, my lords, against that recorded owner, my lords. There was both the parties arrived at a compromise and recording that compromise, that suit was disposed of.
The disposal of the suit was on the date much after the death of the original owners.
No, my lords, they are not the owners, my lords. The opposite party, the counsel for the respondent, who alleging that the person who are dead, they were not the party to the suit, my lords.
That's the whole point. That's what he's saying. They are the original owners. The original owners sold these very lands to these people.
My lords, that's what they are saying, and for that they have filed a civil suit, my lords.
That has
The original recorded owner sold the land to the appellant, my lords, and since some dispute arose, that's why the appellant filed a suit. And both the parties arrived at a compromise, and recording that
The party itself was not there, sir.
my lords,
The party was
that
not
I'm
there. The
clarifying, my
party
lords.
was dead.
This dead person which they
And
are
how could
claiming
you
that
find Wakalatnama for a dead person? That
Well,
was the whole point.
my lords, we have not filed. Some other persons have filed, my
Who
lords.
is filed, sir?
They are alleging, my lords.
Not for alleging. The dates of deaths and the date of the decree will tell us.
My lords, that they had made allegation against those councils.
No.
To the bar council,
Death
they have rejected
Death certificate has to show what is the actual date of death.
my lords,
The dates of death are 1990 and 1993.
my lords, they have been made party because they also hold the land in the same khata.
Yes.
Which khata this land falls.
Right.
That's why we had made them party,
Right.
and we have nothing to do as to who appeared for them. And then
No, you have everything to do, sir. You are benefiting by the compromise decree. How can you say I have nothing to do?
but they are not the party to the compromise, my lord.
Who is they?
Those dead. The person who is alleging that they are dead by 1990, they were not the party to the suit,
Show us the compromise decree.
my lords.
That is Annexure 3, page 12 of the read petition.
Read petition, my lords. Page 12 of the read petition, my lords.
Yes.
Lords, your lordship may kindly see. So
These patros are all
my lords, they are not the Purushottam Patra and October Sahu which they are claiming, my lord. Nowhere Purushottam Sahu and October Sahu are party to this case, my lord. We have made them party in the mutation proceeding because they are the khatadars. They have the land in same khata, and in which khata this land falls. The land which the petitioner wants to mutate in her name. That's why we have made, because their lands are
no. Annexure 4. Let's come to Annexure 4.
my lords.
Before the Tahsildar. This is the whole point.
My lords.
So before the Tahsildar, there were parties.
My
Yes,
Natavar, Sahu and
Purushottam
Purushottam
Patra.
Patra.
Yes, your lord.
And that's the
civil
date
court,
of
they are not
Wakalatnama is
party.
17/2008.
My lord, exactly, your lordship. Kindly consider to what extent a fraud can be committed.
Correct.
My lords,
Correct.
my lords,
And your
they are
lordship,
alleging
next
fraud.
annexures are 2 death certificates.
They are alleging fraud, and we seriously dispute that.
You can do
Because they are
that.
alleging, and they can raise all these they can all these things before the appellate authority, my lords.
Anyway, why should
They have not explained
This is
what
a
prevented
case of
them
fraud.
for the
This is a
appellate.
case of fraud. You see,
They have not provided anything to prove that the appellant has played the fraud, my lords.
all right. You
Nothing
see,
is there on that, and they have not stated anything what prevented them to file the appeal after the order of a mutation proceeding. In the mutation proceeding, my lords.
all right. Agreed by an order dated 17th February 2016, passed by the learned single judge, allowing writ petition civil 527 of 2012 filed by the respondents herein. Respondents 1 and 2 herein. The appellant has filed the present appeal. Paragraph. The said writ petition civil 527 of 2012 was filed by the respondents 1 and 2, questioning an order dated 10 July 2008, passed by the Tahsildar Behrampur in MC 788 of 2007, directing that the mutation that the record of rights in respect of land of a total area of AC 0.542 decimal in Sabik Khata number 82, plot number 110, corresponding to original Hull Khata number 174/108, Hull plot number 110 in Mauza, Neelakantapur, Tehsil, Behrampur, District Ganjam, be recorded in favor of the prevalence. Full stop. It was stated that it was averred in the writ petition that the original owners, Purushottam Patra and Natabara Sahu, had sold the land in question to the respondents 1 and 2 herein. And their respective names were recorded in the ROR. Full stop. Subsequently, the present appellant had filed CS number 266 of 2006 in the Court of the Civil Judge, Senior Division, Berhampur, against certain persons, without making the original owners or the present owners parties to the suit. A compromise decree was passed in the said suit, allegedly in collusion and on that basis, a mutation case, MC number 9788 of 2007, was filed before the Tahsildar. Full stop. The allegation is that in the proceedings, in the aforementioned mutation case, a wakalatnama was purportedly filed on behalf of the original owners, Natabara Sahu and Purushottam Patra, on 1st July 2008, and there no objection to the mutation in the ROR was recorded. Paragraph. Both the respondents 1 and 2, that is the writ petitioners, were able to produce before the single judge copies of the death certificates of both Natabara Sahu and Purushottam Patra, which showed the death to be 24th September 1990 and 4th June 1993, respectively. Thus, the wakalatnama produced before the Tahsildar on 1st July 2008, copy of which was also annexed to the petition's Annexure 4, purportedly showing that 2 persons had authorized a lawyer to appear on their behalf, was clearly a fraudulent document. Full stop. Paragraph. Since fraud vitiates all transactions, the learned single judge had no hesitation in holding that the mutation of the ROR in favor of the present appellant was non-honest and unsustainable in law. Paragraph. Learned counsel for the appellant submitted that respondents 1 and 2 had an efficacious alternative remedy of challenging the order of the Tahsildar before the sub-collector by way of an appeal, and the writ petition therefore could not have been entertained. Full stop. Since this was a case of a clear fraud being made on the Tahsildar to get the mutation of the ROR in their favor, in favor of the present appellant, the learned single judge was justified in interfering with the said order in exercise of jurisdiction to Article 226 of the Constitution. Paragraph. The court is not persuaded that any error has been committed by the learned single judge in entertaining and allowing the writ petition filed by respondents 1 and 2. There is no merit in the present appeal. It is dismissed.
Item number 18.
The interim order.
The IA 831 of 2018 is disposed of.
My lord, applies to.
Item number 18.
None appears dismissed.
Item number 19.
On behalf of Mr. Maharti, may I please your lord? My lord, the matter relating to my lord appointment under rehabilitation assistance schemes, my lord. My lord, challenging Annexure 9 to the writ appeal, my lord. The writ petition has been filed. Prior to place the impugned order, may I permitted to place the impugned order to the writ petition, Annexure 9, page 23, my lord. May I place it, my lord?
Carry on, sir, carry on.
My lord, my lord, the father of the petitioner died on 18/12/2000, my lord, while the rehabilitation assistance rule is adopted by the corporation, my lord, opposite parties. My lord, sir, please refer to the letter on the subject cited above. You are requested to furnish the required documents for consideration of sanction one-time financial assistance amount of rupees 1,50,000 only to the family of the deceased employee under RAS. Instead of submission of the said documents for receipt of RAS benefit, you have represented for appointment.
There is no RAS, sir.
RAS means, my lord, rehabilitation assistance scheme. My lord.
No, there is no RAS. They have now substituted by a new system of compensation. That's it.
No, their compensation, but my lord, the Honorable Apex Court, the recent judgment is that the rule which is in force at the time of demise may be upheld.
That has been referred to a larger bench, sir. In the Supreme Court itself, it has been referred to a larger bench.
Larger bench, my lord, 3-member bench, that is my lord, State of Madhya Pradesh and others versus Amit Srivastava, my lord. Civil Appeal number 8564 of 2015.
So that matter is already pending with the larger bench. You see, since the issue regarding applicability of the RAS scheme, which was in force at the time of death of the government employee,
my lord. But
is before a larger bench of the Supreme Court, the present writ appeal is adjourned with the permission to the parties to mention it for listing after the disposal of the matter by the larger bench of the Supreme Court.
Item number 20. Item number 20.
None appeals dismissed.
Item number 21.
None appeals dismissed.
Item number 22.
22, my lord, matter has become infructuous.
All right, infructuous dismissed.
Item number 23.
Pass.
Item 24.
None appeals dismissed.
Item number 25.
None appeals dismissed.
Item number 26.
May I please, your lordship?
Delay.
My lord, the petitioner was the owner of a tipper truck. His truck was stolen on 26th of January 2015 night, and he made a search on 27th, and on 28th, since he did not file an FIR. There was a valid insurance. He also applied to the insurance company on 11th of February 2015.
How is this not amenable to jurisdiction at all, sir?
Your lordship may kindly have a glance to read.
I don't know how these learned single judges pass such a long judgment.
Your lordship,
this not maintainable at all.
My lord, the learned single judge has not taken into consideration to the fact at page 27 of the permanent Lok Adalat's order, it says at page 27, we have given anxious consideration to the above submission in the circumstances of the case. We are of the view that the case needs to be treated on non-standard basis. As per Regulation 10 and Subpara 3 of the regulation framed by the Insurance Regulator, it provides that where there is a breach or warrant conditions of insurance policy, including the limitation as to its use, then the compensation is payable up to 75% of the admissible compensation. Reason being that this case is squarely covered under the aforesaid regulation. Reference we made, Kesara 1 versus United Insurance Company, 2000 CPJ page 36, and another judgment. In view of the aforesaid discussion, and when there is cause of bring the application, we are of the considered opinion that the appellant entitled to receive 75% of the sum assured under the questioned policy on non-standard basis. This aspect has not been taken care of by the Honorable Single Judge. Your Lordship may kindly have a glance to the judgment of the Honorable Single Judge. Only because there is a violation of the contract, therefore basing on a Supreme Court judgment, Your Lordship, I am taking the relevant portion at paragraph 6. This has, without considering this aspect, only relying on a judgment where that is not a case of non-standard claim. Basing on the judgment of the Honorable Supreme Court, non-compliance of the contract, and hence hold that he is not entitled to get the compensation. Your Lordship, I am placing paragraph 6 is the relevant paragraph. Reading the aforesaid two conditions, it became crystal clear that not only notice is required to be given to the insurance company in writing on the theft of the vehicle or damage of the vehicle, but it also mandated that such information should be made to the company immediately after the occurrence of any accidental loss of damages or in the event of any other claim so and so. From the facts scenario narrated herein above, since the theft took place on 26th of January 2015 and the affair lodged on 28th of January 2015, and also intimation to the insurance company being made on 11/2/2015, it is apparent that there has been violation of the condition of number 1 contained in the insurance policy. Now coming to the condition number 5. Reading the condition quoted herein above, it becomes apparent that it is also the duty of the owner of the vehicle who should take all reasonable steps to safeguard the vehicle from the loss of damage. The fact narrated herein above clearly reveals that the opposite part number 2 remained careless, leaving the key as well as the original document of the tipper inside the vehicle, even when the vehicle remained totally idle, and thereby failed to safeguard the vehicle insured from the loss or damages. The plea of opposite part number 2, that one of the key of the vehicle was damaged and he left the key only inside the vehicle, is a clear admission of the opposite part number 2 did not take sufficient measure safeguard the vehicle from the loss. Conditions in the policy are being nature on the both sides, and violation of the binding condition debar a person from being entitled to compensation on account of loss of the vehicle. Even though the parties have referred to several decisions in their favor, this court find no necessity for referring to those decisions for difference in the factual scenario. There in the position of law, this court finds the Honorable Apex Court in the case of Oriental Insurance Company Limited versus Prabhat Chandra Chadha, civil appeal number so held as such. Paragraph 12 quoted, since the term and condition of the insurance policy which is insured had issued to the complainant in Prabhat Chandra Supra had been reproduced in the order of the Honorable Supreme Court, we persuaded the order passed by the Commission in the above referred case. However, the term and condition of the policy were not reproduced even in the judgment of the Commission. It, however, became evident from the perusal of the judgment that the insurance policy was issued for the period from 17/1/95 to
anyway, that's all not important. In your case, both the conditions were not complied with. You gave the information only 11th February, so long after the theft.
Even then also, the permanent Lok Adalat for the regulation framed by the insurance company. Your Lordship, I have brought your Lordship's kind notice to page 27 of the writ petition, where the permanent Lok Adalat taking into consideration this vis-a-vis the regulation 10 of the regulation framed by the regulatory authority, have held that even if there is violation of conditions, they are not entitled for the 100% compensation, but they are entitled for 75% of the compensation. So, Lordship, may kindly have a glance to page 27 of the writ petition.
Yes.
That is, and taking into this aspect, regulation 10 subpara 3 has not been taken into consideration by the Honorable Single Judge. And regulation 10 subpara 3 provides, what is there violation of the conditions, the claimant is entitled to get 75% of the compensation. This aspect, which has been dealt with by the permanent Lok Adalat,
subject to compliance with all other conditions.
All other conditions has been
you have not complied with those two conditions, sir. Immediate intimation was not given, and then of the vehicle in the vehicle itself. It's clearly carelessness.
Those two judgments I have referred to before the permanent Lok Adalat, which says even if some of the conditions are not complied with by the claimant, still then, as per Regulation 10, subpara 3, the claimant is entitled to get 75% of the compensation. That is the fact which the Permanent Lok Adalat has taken into consideration, though this was placed before the Honorable Single Judge, but the Honorable Single Judge has not attached such importance to this paragraph and disposed of only by saying that the conditions has not been complied with.
All right. The appellant is aggrieved by an order dated 28th March 2017 passed by the Learned Single Judge, allowing writ petition civil 15067 of 2016 filed by the respondent insurance company, whereby it had questioned an award dated 30th June 2016 of the Permanent Lok Adalat, directing the company to pay 3/4 of rupees 1125,162 as compensation to the present appellant for the loss of his vehicle, which was under the insurance cover of the respondent insurance company. Paragraph. The appellant owned a Tata tipper truck, which was insured with the respondent insurance company for a period from 29th March 2014 to 28th March 2015, midnight. Full stop. The vehicle got stolen on the night of 26 January 2015. Full stop. The appellant stated to have lodged an FIR with the BNpur police station, bracket PS, in Ganjam district on 28th January 2015. Full stop. Intimation was given to the respondent insurance company of the said theft on 11th February 2015. Full stop. However, the insurance company was of the view that there was violation of the insurance policy, and in particular, condition number 5. Full stop. Agreed by the non-processing of his claim, the appellant then approached the PLA, functioning under the in terms of the Legal Services Authorities Act 1987. Full stop. Paragraph. The said PLA case number 8 of 2015 was allowed by the PLA, directing the company to pay the appellant 3/4 of the value of the Tata tipper, as indicated in the insurance policy. If the amount was not paid within 2 months, the appellant was held to be entitled to interest at 9% per annum from the date of filing of the application till the date of the payment. Paragraph. As already noticed, the insurance company filed writ petition civil 15067 of 2016 in this court, agreed by the said award of the PLA in PLA case number 8 of 2015. Full stop. The Learned Single Judge has in the noted that 2 conditions of the insurance policy were violated. Full stop. One was condition number 2, which required condition number 1, which required the policyholder to inform the insurance company of the theft. In the present case, there was a delay of well over 10 days in giving such information to the insurance company. Full stop. There was a condition number 5 of the insurance policy specifically indicated that all reasonable steps had to be taken by the policyholder to safeguard the vehicle from loss or damage. Stop. It was specifically indicated, open quotation, in the event of any accident or breakdown, the vehicle insured shall not be left unattended without proper precautions being taken to prevent further damage or loss. Unquote. In the present case, the Tata Tripper truck was left unattended in the ignition switch without anyone being in the vehicle. Stop. This was viewed negatively by the learned single judge and correctly held to be in violation of condition number 5 of the insurance policy paragraph. Counsel for the appellant placed considerable reliance on regulation (10)(3) of the regulations framed by the Insurance Regulatory Authority, which provides that where there is a breach of warranty of the conditions of the policy, including limitation, then compensation payable would be up to 75% of the admissible compensation. Where is the full text of the clause? Which page? The full text of this 10.3.
Sorry, at the point I am not holding that.
It's okay. Paragraph. It is submitted that the above clause was not taken note of by the learned single judge. Paragraph.
This has been referred in the judgment of the PLA at page 27 of the.
No, that I have not. In the present case, the condition of condition number 5 appears to have been clearly violated. Stop. The facts reveal that the driver fell asleep. Was sleeping in a cabin nearby leaving the vehicle unattended with ignition switch. Full stop. This is not a mere breach of condition, but obvious negligence leading to the theft of the vehicle. Full stop. Consequently, the court is not satisfied that Regulation 10(3) would apply in the facts and circumstances of the case. Full stop. The view taken by the learned single judge does not call for interference. The appeal is accordingly dismissed.
Item number 27.
None appears dismissed.
Item number 28.
On behalf of Mr. B. Mohanty, my learned senior, permission to withdraw.
Counsel for the dismiss is withdrawn. Correct.
Item number 29.
None appears dismissed.
Item number 30.
Billets, I pray only 2 days time to remove the defect billets.
So 2017 matters.
Lordship, item 30 earlier, Lordship, it's the date, 5th of December. Trade certificate matters.
You're helping him, sir. This is a trade certificate matter.
Lordship.
Correct. List on 5th December.
5th December, Lordship.
Correct. This is, he's appearing in 30, page 1, I think.
Lordship.
He's appearing in 30, sir.
Sorry.
You're just appearing in a wrong matter and saying something.
Sorry.
Very strange. What's the matter about 30?
Let's application challenging the order of the single judge under
Penal
annexed
quarter rent,
P billets.
retention of government quarter beyond prescribed time. If you retain it beyond the time, you have to pay penal rent, sir. Only 28,800. Nothing, there's no ground made out. You see, challenge in the present writ appeal is to an order dated 4th May 2017, passed by the learned single judge, dismissing writ petition civil 6160/2017, filed by the present appellant. Paragraph: the appellant was asked to pay rupees 28,800 as penal charges for retaining by the Cuttack Municipal Corporation for retaining the government quarter beyond the prescribed time, for the period from 1st December 2004 to 31st March 2006. Paragraph. According to the appellant, he should have been only asked to pay the regular rent. Full stop. However, the fact remained that he had retained the government quarter beyond the prescribed time limit and therefore was liable to pay penal rent for the extended period. This being purely factual, the learned single judge found no reason to interfere. Full stop. This court is also not satisfied that any ground has been made out for entertaining the present appeal. The appeal is accordingly dismissed.
Item number 31.
30 is 5th December. 31 is 5th December. Yeah.
31
Item
5th December.
Item 32.
My lord, pardon to mention item number 29 on behalf of Mr. Mohanty. My lord, not press. Item number 29.
29 dismisses, not pressed.
My lord, in item number 32, the sole appellant had died. So I pray 2 weeks time to file substitution.
When did he die?
My lord?
When did the death take place, please?
I pray 2 weeks time to file substitution.
Madam, have you understood the question? You ask the question.
When did the appellant died?
That part I don't know. I have to seek information.
Then we are not able to help you, madam. It appears that the sole appellant has died. Counsel of the appellant is not even aware of the date of death. Stop. The appeal is dismissed as having abated.
Item number 33.
We don't know that he's telling that.
Well, in this case, sole opposite parties. Now the opposite parties died. On 21,
Let us see if you are entertaining the appeal at all. What is the appeal about?
Yes. Yes.
What's the delay? 16 days.
All right. Because
delay is condoned.
Because before admission he has appeared.
Yes. What is the appeal about? Let us see.
Nowadays, short death that is there. There.
About pension being paid to the respondent.
Yes. Let me briefly submit.
Yes, yes.
My lord, earlier there was Moyurbhanj State Bank. Before State Bank was there, Moyurbhanj State Bank and different banks were there. And also Imperial Bank, that your lordship knows. And he was an employee of that bank. Then that bank, that was merged. Ultimately merged with the State Bank of India after the State Bank came into force. Then before that, the petitioner, the respondent number 1 had been retrenched from the erstwhile bank. Then it was, sorry my lord, before that, it was taken over state government and then from state government to State Bank of India. Then what happened in the pension rules, provision, that means State Bank of India's pension rules, there is a provision that those who are above 35 years age, this pension rule does not apply. And there is another provision, rule 22, that those who have rendered 20 years of service, only they will be entitled to pension. That means these two provisions are independent of each other. So they were not, he was not entitled to pension. One such employee, in the Bombay High Court case was filed.
This man was absorbed in the SBI as a fresh entrant in 1961.
Yes.
And he died in 1983.
No.
Yeah,
3562,
sir.
3561, he was retrenched by the district magistrate from the state.
I'm your date chart.
Yes, yes.
Come to page 2, top.
Yes. Then thereafter he was observed in state.
What's the date?
That was 3561.
When did he retire? 24/4/83.
83.
So minus 83 minus 61 is what? 22.
That is 22. But he is not admitted to pension because he was above 35 years and 22 years. That is for the State Bank of India employees. 22 years, but not to this employee. But that is why the Supreme Court judgment, we are governed by the Supreme Court judgment. That Supreme Court judgment, let's kindly see, that is quoted. That is quoted, that is also referred. That your lordship kindly see, page 8. Page 8 of the writ appeal, and also that is there in the writ petition. May I read it, my lord?
Yes, sir.
Yes. But Nipun order is set aside in view of the State Bank of India. Well, that order was passed in favor of that employee, similarly situated employee. By consent, the impugned order is set aside in view of the State Bank of India having taken into discussion to decision to grant pensionable benefits to the employees of the erstwhile KB Bank Limited, who are appointed in the State Bank of India by counting the service rendered in the former bank, subject, of course, to the employees meeting the requirements of the State Bank of India employees pension with regards to eligibility criteria, and further on their surrendering the gratuity, interest, and any other similar benefits received by them. The SBI has also taken a decision to extend the same benefits to the employees who are observed in the State Bank of India from other private banks whose business were taken over by the former. The only dispute that remains between the parties is in regards to claim of interest on the gratuity or similar benefit taken by the employees, which they would be required them to surrender under the scheme by which pensioner benefits are extended to employees of banks taken over by the State Bank of India. Mr. Harish and Salve, Lord and Senior Counsel, vehemently contended that since the employees had the benefit of amount which they withdrew by way of service gratuity or any other similar benefits, the interest on that amount which they must have earned should be received by the State Bank of India. But this contention is countered by the Learned Counsel for the respondents on the ground that in that event, the employees would be entitled to interest on pension. Taking into consideration the rival contention, we are of the opinion that the requirement of payment of interest on the gratuity or similar benefits needs to be dropped. We therefore do not consider it appropriate to direct the employees to pay interest on the gratuity or similar benefits received by them in existence. Except for this modification, the scheme contained in the resolution of 26 August 94, appended as Annexure A to IA 6 of 94 is approved and will stand substituted for the main judgment and order. The State Bank of India may work out the scheme as early as possible within a reasonable time. So he is governed by the scheme. He is not governed by the pension rules. So Lordship, may I draw your Lordship's attention to the pension rules that.
So come to first tell us what is wrong with the judgment of the single judge.
Impugned judgment of the single judge is wrong because
no. First read out, sir.
I am reading out. Yes,
page 83. Come to page 83, paragraph 27 onwards.
I am grateful to your Lordship. I was to draw something attention because 10 o'clock getting the list and to read the brief is a very difficult task now. 63 pages.
It's become a standard thing, sir, for you. Every matter, seek an adjournment saying 10 o'clock.
No, at least I'm
unable to read.
No, at least 7
you start arguing for about 10 minutes. When I start asking questions, you say 10 o'clock I got.
My lord, at least 7 days before we should get a
all right.
Notice of
senior counsel says he's not prepared to argue the.
No, I am arguing the matter.
At his request, list on 6th February.
Item 34.
Let him give the death of the employee so that I can substitute that. No, otherwise, I am ready to argue. I am ready to argue.
It's all right.
Item 34.
None appears dismissed.
Item number 35.
May I please, your Lordship? It is a trade certificate tax matter. So the batch of trade certificates matter was posted to 5th December. Kindly be tagged up and come on 5th December.
All right. 5th December.
Item 36.
None appears dismissed.
Item number 37.
None appears dismissed.
Item number 38.
38, my lord. Respondent number 2 and 3, respondent number 3 and 4 filed a suit 146 of 2011 for suit for partition, declaration of cell deed as null and void, and injunction. Then after to the page 5 of my miscase, Annexure A by 2 and B by 2, 2012, they have filed a consolidation revision, self-same relief for declaration of cell deed as null and void. Now, the doctrine of election, you cannot choose the two forums for self-same relief. I am citing a decision of the 93 Supreme Court, 1222.
The other side being served.
Page, relevant page is 1224. Decision, my lord. Paragraph 6, my lord.
So notice is not gone in this appeal?
Yes, my lord. Not gone.
Where is the single judge's order, sir? Which page?
Single judge order, my lord. I have annexed, my lord. The relevant page is paragraph 6, my lord. He has dealt with paragraph 4, the decision of the doctrine of election. The main contention of Mr. Udgata, Learned Counsel is that when two forums are available to the parties.
This is a writ petition, sir. It's not a 226. You have assailed an order passed by the Additional Commissioner Settlement and Consolidation.
Yes, ma'am.
In revision case.
Yes, yes.
So it will be a 227. How will writ appeal is not maintainable, sir? Writ appeal is not maintainable. You see, from the impugned order dated 31st August 2017, passed by the learned single judge, it is plain that what was challenged in writ petition civil 15042 of 2017 by the petitioners was an order dated in January 2017, passed by the Additional Commissioner Settlement and Consolidation in revision case number 148 of 2012. So this was plainly an exercise of jurisdiction by the learned single judge under Article 227 of the Constitution of India. Stop. As such, the present writ appeal is not maintainable in view of the judgment of the Supreme Court in, I think yesterday that citation is there. Leaving it open to the appellant to seek other appropriate remedies, the appeal is dismissed. Life Insurance Corporation of India versus Nandini J. Shah, 2018-15 SEC 356.
Item number 39.
None appeals dismissed.
Item number 40.
My lord, item 40, 41, 42, no instruction.
No instructions. 41, 41, 42. Right.
Item number 43.
My lord, in item number 43, my lord, I am challenging the order under Annexer 8 at page 67, passed by the learned single. Page 69 is the order. Order dated 39/2017. My lord, this is arising out of a, my lord, proceeding, where mutation proceeding filed before the Director of State, my lord, wherein the present appellant filed a memo stating that a suit is pending, my lord. Pursuant to the information made by the present appellant, my lord, the Director of State, he dropped the proceeding. Challenging the said order, writ petition has been filed before the learned single judge by the present respondent, my lord. The order is at page 69. I am placing that order, my lord. Hard learned counsel, my lord, in this writ petition, though I am a party before the Director of State, but present appellant has not implemented as a party, my lord. Hard learned counsel for the petitioner and learned additional government advocate. This is the second journey of the petitioner to this court. His earlier application bearing WPC number 13460 of 2017 was disposed of on 12/7/2017, directing the OP number 2 to dispose of the mutation application as expeditiously as possible. But before the petitioner produced the certified copy of the order, before the OP number 2, he disposed of the mutation case and intimated the petitioner
Where
that
is the
Annexer
counsel
1.
for the respondent number 1?
My lord. My lord.
Counsel for the respondent number
My lord,
1.
Mr. Bose is appearing. My lord, here my lord, he is appearing for the
opposite party number 1. So why don't you come to the mic, sir? You're not audible.
I'm appearing for the opposite party number 1, my lord, here.
All right, all right.
My lord, the relevant portion is in the middle, my lord. The contention of the learned counsel for the petitioner is that though the property in question was recorded in the name of his father, my lord, this is the, from the very beginning, it is brought to the notice of the learned single judge that a will has been executed by the father in favor of the respondent, which is false throughout, my lord. It is incorrect fact, which is brought to the notice of the learned single judge. And this is on the basis of the submission. No affidavit has been filed, neither the will has been produced before the learned single judge. Of the learned counsel for the petitioner is that though the property in question was recorded in the name of his father and he died leaving behind the petitioner and 3 daughters, between whom the suit for partition is pending before the learned civil judge Bhubaneswar, this property has been bequeathed in favor of the petitioner by his
only say
father.
that the mutation will be subject to the outcome of the civil suit. We can clarify that.
Civil suit is pending, my lord.
So we'll clarify that this mutation will be subject to the outcome of the civil suit.
But my lord, my only submission, your lordship.
And there are certain conditions imposed by the honorable single judge while remanding the matter, that he will verify that whether the will has been probated or not.
The fact, my humble submission is the observation made by the honorable single judge may affect the.
We'll say it will not.
Oh, it will not.
Because my lord, the neither
clarify that it will not.
My lord, it is not correct that any will has been executed by father and that is probated, my lord.
You say
that is to be verified by the authority.
It appears that
that is not produced.
The civil suit filed by the present appellant seeking partition of the properties in question is still pending in the civil court. The apprehension expressed by counsel of the appellant is that the observations made by the learned single judge on merits in the impugned order might affect the outcome of the said suit. Stop. It is apprehended that the mutation ordered by the learned single judge by the impugned order might become final and render the suit itself infructuous. Paragraph. To allay the apprehension, it is clarified that no observation made by the learned single judge on merits in the impugned order will affect the outcome of the pending civil suit, and further that the mutation ordered will itself be subject to the result of the civil suit. All right. With these clarifications, the appeal is disposed of.
My lord.
Item number 44.
None appeals dismissed.
Item number 45.
None appeals dismissed.
Item number 46.
None appeals dismissed.
Item 47.
The memo is taken on record. Dismisses withdrawn.
Item number 48.
May I please? There is delay of 2 days only, and
all right, delay is condoned. Yes, tell us what the matter is.
The honorable single judge has dismissed the writ petition on the ground that the writ petition involved disputed question of facts and that the petitioner had not availed the alternative remedy provided under Regulation 110 of the OERC Conditions of Supply Code 1998. So,
what's your answer to that?
Madam, the petitioner has already availed the alternative remedy provided in Regulation 98 pursuant to direction of this honorable court in the previous writ petition. That is, the order is quoted in the writ petition, my lords, that there are 2 remedies provided in the 98 code. One under Regulation 52 of the code. Your lords may permit me to supply extracts of that regulations for reference. I have given the first page of the regulation and other relevant. Regulation 52 in the second page, my lords.
Yes.
This remedy is provided exclusively for dealing with the inspection reports. My lords. During the checking and verification of the electrical installation in the premises of the consumer, including the supply line and meter, a complete inventory shall be prepared for all connected equipment, apparatus, machineries forming integral part of the premises of the consumer. The consumer or his representative shall be requested to sign the inventory or inspection report. If the consumer or his representative refuses to sign the inventory or the inspection report, an endorsement to that effect shall be made by the engineer on the body of the report. A copy of the said report shall be affixed at the consumer's premises. In such cases, the consumer shall be deemed to have been served with a copy of the report. Within 1 month of service of the report as aforesaid, the consumer shall be entitled to complain against the correctness of the inventory or the result of the inspection to the designated authority of the licensee, who shall inquire into the matter of the complaint and decide on the correctness or otherwise of the report. So after the inspection, alleging that the consumer has tampered with the meter, the petitioner made a complaint under Regulation 52 before the designated authority, challenging the report and the result of inspection, my lords. But the Honorable Single Judge, referring to Regulation 110, my lords, I have given that. 110 is a general provision for all types of grievances of the consumer. And to the same authority also. 110 subclause 1. A consumer aggrieved by any action or lack of action by the engineer under this code may file a representation within 1 year of such action or lack of action to the designated authority of the licensee of engineer, who shall pass final orders on such a representation within 30 days of receipt of the representation. So this is a provision.
No, I think 110.2 is what the judge
the consumer agreed by the decision or lack of decision of the designated authority of the licensee may file a representation within 45 days to the chief executive officer of the licensee, who shall pass final order on such a representation within 45. So any person who is agreed by the decision of the designated authority passed in exercise of power under 110.1.
No. 52, sir.
There is no provision for appeal.
No.
52, there is no provision.
No. 102 is 110.2 is against any decision, not only 110.1 decision. 110.2 applies to any decision of the designated authority or a lack of decision. So if you have filed something under regulation 52 and it was not decided, you said you had filed a complaint under regulation 52.
52 and it was rejected.
So against that you can go and appeal to the chief executive officer under 110.2.
Well, this is under this to decision, a consumer agreed by the decision. Here decision means the decision taken under 110.1.
No, it doesn't say that. Where does it say? It does not say that, sir.
Because that decision of the designated authority and that apart, my lords, so far as disputed question of facts is concerned, my lords.
No, but what is your answer to this? Why didn't you go before the chief executive officer?
Well, under the impression that there is no appeal provided against
anyway, now that you know there is no stay also here. Is there a stay of the impugned order?
No, man.
Sir. You could have gone to the CEO and be done with it.
Only notice on the question of limitation was issued.
Anyway, limitation is what, 4 days, is it?
Only 2 days.
2 days is allowed anyway, so.
Minus. So only so far as here what happened.
Yeah, nothing, sir.
During the
there's nothing in this.
My lords, only lordship may allow me 1 minute only. So there is no question of any disputed facts which should be decided by the technical expert, my lords, because there is during pendency of the matter before this honorable court, the meter was tested by the opposite party and a parallel new meter was installed, and both the readings consumption in both the meters were tested and found similar. And annexure 19 to the read petition is the letter of the executive engineer
for what happened before the installation of the new meter.
No, the
penalty is for what happened before the installation of the new meter.
Because they did not remove the old meter, that was kept as it is condition. They sealed it, and they subsequently installed a new meter in series with the old meter.
Correct.
The
penalty is for what happened before they sealed.
The meter was never tested. Only because they found allegedly that the seals were broken, they presumed that the meter was interfered with and penalty was imposed.
Yes.
But the report shows the meter was never tested.
Yes.
So because the seals were broken, it does not mean ipso facto that the meter was not recording the actual
absolutely, sir. That is more than enough. If they find on surprise check that the seals are broken, then the penalty
for testing the accuracy of the alleged tamper meter, they tested it and found it is recording actually.
Yes.
So thereafter, they should have withdrawn the penalty, which they have not done. And that documents were filed before the single bench.
Yes.
And the single bench also, during earlier orders, directed the other side to take instruction on that document, testing report, which was not supplied even after undertaking to furnish such reply. And the Honorable Single Judge has not considered those documents, my lords.
Right. So this is the second round of writ petition. Earlier you had filed 3049 of 2002. Then they asked the designated authority to this complaint. So clearly you had to go to the CEO against that. You said the challenge in the present.
He had gone to the CEO. Your Lordship kindly have grants to the Annexure 12 to the writ petition. And CEO has also passed the order. Annexure 12 to the writ petition.
No, that is not an appeal letter of CEO.
In earlier writ petition, according to order of the earlier single judge, he had gone to the Annexure 12 petition. He has challenged that authority of that CEO, whether he has got jurisdiction, and that has been answered.
No. This is not the CEO's order, sir.
But designated authority.
Against a designated authority, you can file an appeal to the CEO.
Senior general manager is the designated authority.
So you're not following what we are saying. Against the decision of the designated authority, you have an appeal to the CEO under 110(2).
Yes. Yes, he had gone to that. So, Your Lordship.
He did not go, sir. That is why the writ petition was not entertained. The writ petition was not entertained because he did not avail that remedy.
Yes. Yes.
Don't have your facts correct, sir. This is the whole problem. You're interrupting.
Sorry.
Kindly take your seat. Yes. The challenge in the present writ petition in this writ appeal is to an order dated 16th October 2017 passed by the learned single judge, dismissing writ petition civil 5088 of 2002 filed by the present appellant on the ground that it had an efficacious alternative remedy of an appeal under Regulation 110(2) of the Odisha Electricity Regulatory Commission Distribution Conditions of Supply Code 1998 hereafter Code . Paragraph. This was the second round of litigation before the learned single judge at the instance of the present appellant. Full stop. In the first round, the appellant had filed OJC number 3049 of 2002, aggrieved by the demand of penalty raised by the respondent electricity undertaking. As penalty under Regulation 105(2) of the Code, pursuant to an inspection undertaken of the business premises of the appellant by the company on 2nd March 2002. Full stop. The said writ petition was disposed of by the learned single judge on 26th April 2002, noting that the appellant had already deposited the 80,000 for immediate power supply. And the power supply had been restored. Full stop. The learned single judge directed the designated authority in terms of Regulation 52 of the Code to dispose of the complaint dated 11th March 2002 of the appellant after giving him an opportunity of hearing. And further that till the decision is taken by the DA, designated authority DA, power supply will not be disconnected to the appellant on the ground that he had not been paid. Paragraph. Thereafter, the DA passed an order on 8 November 2002 upholding the tampering in the meter and also the penal bill. Full stop. This led to the second round of litigation with the appellant filing writ petition civil 5088 of 2002, assailing the penal bill. Full stop. The learned single judge has noted in the impugned judgment dated 16/10/2017 that under Regulation 110(2) of the Code, the appellant had the remedy of an appeal before the Chief Executive Officer. Full stop. Counsel for the appellant referred to Regulation 110, which reads under A to A. It was submitted by learned counsel for the appellant that under 110(2) of the Code, an appeal will lie only against a decision of the DA under 110(1) and not the decision of the DA under Regulation 52 of the court paragraph. The court is unable to agree with the above submission. Full stop. There is nothing in the wording of 110(2) which limits the appeal to the CEO against the decision of the DA taken only under 110(1) of the code. Full stop. The wording is general and could easily accommodate appeal against the decision of the DA even under Regulation 52 of the code paragraph. In the circumstances, the court is unable to find any error having been committed by the learned single judge, which calls for interference. The appeal is dismissed.
Supplementary list item 49.
May I please, my lord?
Yes, please.
My lord, here, your lordship, I may be pardoned, though Annexure 1 is in Oriya. Fact remains the property in question was recorded in the name of Jagannath Mahaprabhu, Marfat Lakshmi Amaju. Why I am stressing upon this? Because it is only the properties which are recorded in the name of Jagannath Mahaprabhu, Vijay Sikhetra. Those are the properties of Lord Jagannath. That is well known. I think even the council appearing for the temple administration will not dispute this proposition. Now, these three persons in the left-hand side are recorded as the Stitiban tenants, namely Baidyanath, Jagannath, and the third person also. Now, the petition of appellant before your lordship are the heirs of Baidyanath. Property in question has been recorded under Stitiban status. Now, so far as Jagannath is concerned, this respondent, they purchased the property from Jagannath. And now they filed a revision.
Siddha Mata case, all this is not debated.
I am not claiming that the property is of Lord Jagannath and therefore I can claim right over it. Because if it is a Lord Jagannath's property, then only I can claim for a settlement in terms of the resolution they have made subsequently. I cannot claim. It has to go to Lord Jagannath. But I just want to make a distinction from record that this is not property of Lord Jagannath, and both the revisional forum and Honorable Single Judge has committed an error apparent on the face of record. This is what I beg to point out. Otherwise, my lord, if this is property of Lord Jagannath, I fail, my lord. I have to approach the temple administration for sale and other things which they have done post facto by virtue of a resolution of the government and also the temple administration. Here, I just beg to point out from Annexure 1 apparently that this property is of a private deity represented by a Marfatar. These petitioners, the predecessor of the petitioner was a Stitiban tenant. Now, the other person who purchased the property went in revision. Your lordship may kindly see the revisional order. Annexure 2, Annexure 3, your lordship. Now, the revisional court rejects their claim. After rejecting the claim, page 17, your lordship, last para, the suit property is apparently of Jagannath Mahaprabhu. So, therefore, it should be recorded in the name of the my lord, Jagannath Mahaprabhu, Marfat Mandir Parchana Committee. This is where, my lord, the error is. Now, my lord, I prefer this writ petition, and in writ petition, your lordship will kindly see page.
What is the exact entry, sir?
The entry is Jagannath Mahaprabhu, Marfat Lakshmi Amaju. So, this is not a property of Lord Jagannath, my lord, Puri. I have even inquired, my lord, if I am permitted to make this submission, my lord, that from the temple administration, my lord, lawyer, that it is only those properties which are Jagannath Mahaprabhu Vijay Sikhetra. Even I was asking if Vijay Puri, it will be of Lord Jagannath. No, not like that. If it is Vijay Sikhetra, then it is property of Lord Jagannath. And those properties, my lord, are saved by decision of the Honorable Appeals Court in 2016 OLR, Supreme Court. I cannot, my lord, deviate from that. So therefore, I will have no case. So here, the apparent error is, this is not of Lord Jagannath's property. And if I have, though revisional forum, the Lord Jagannath temple administration was not a party, here I have made them parties.
Then you can file a review petition. If you say it's an error of face of the record, you file a review petition.
But here also I have made Sri Jagannath Mahaprabhu a party through the committees.
No, but the single judge order clearly proceeds on the basis that it's recorded in the name of Lord Jagannath.
But that is the difficulty.
So you file a review.
But also the revision
counsel for the
same error.
Appellant submits that there is an error apparent to the face of the record in as much as the learned single judge has in the impugned order noted that the property involved in the case is recorded in the name of Lord Jagannath Mahaprabhu, whereas according to the appellant, it is not so. If in view of the above contention, the learned counsel for the appellant seeks to withdraw the present appeal with liberty to file a review petition before the learned single judge. Petition seeking review of the order of the learned single judge in accordance with law. The writ appeal is disposed of as withdrawn with liberty is paid for.
Obliged.
Item number 50.
Will your lordship be kind enough to make observation with regard to the limitation, because I have
All right. You see, the learned single judge is, you say, no, there's no need for the observation. You will obviously delay, sir.
Obliged.
Item number 50.
Item 50 and 51, no instruction.
No instructions.
And then item 50, 51, 54, 60, all four matters arising out of the policy matter. Yesterday, your lordship dismissed the.
He's saying no instructions, sir. We're already dismissing it. When we come to 54 and 60, we'll see.
Item 52.
Lord, item 52, though a very trivial issue is involved here in this writ appeal, but I find that notice with regard to this contesting respondent is not sufficient. So far as 2B and A is concerned.
Right.
So far as respondent 6 is concerned, your lordship may permit me, I'll serve an extra copy on the state because it's a consultation officer. The state council will receive a copy.
All right.
2A, B, C, my lord, phrase steps in both the ways, my lord. I'll try to take notice through court's process also. Otherwise.
Okay, fresh notice to 2ABC. The registered post be tracking report be placed on record for the next date. As far as respondent 6 is concerned, the copy be served now on counsel for the state. Orissa. List on 4th.
Good. There is an interim order dated 4th of February 2019.
2nd February. All right.
Great.
Interim order to continue.
Item 53. 53, sir.
Here I want 2 weeks time to take steps for limitation.
No. What's the limitation? Tell us. There's a delay of 215 days. Far from explaining the delay, steps have not even been taken to file an application for continuation of delay. Consequently, the court is not inclined to condone it. The appeal is dismissed.
Item number 54.
None appeal is dismissed.
Item number 55.
Item 55. So I have filed a writ appeal based on amending provisions of Regulation 2 of 1956, which was amended with retrospective effect from the regulation came into force. But there is a judgment passed by this honorable court, which says that the sales which have been effected prior to the amendment, they are all saved. So in that view of the judgment, on merits, I will not have a case before your lordship.
All right.
So there is a delay of about 4 months. On the ground of delay, your lordship may dismiss it.
All right. Unexplained delay of 106 days has not been properly explained.
116. 116.
116 has not been properly explained.
Yes.
Consequently, the court is not inclined to condone it. MC number so and so is dismissed. Consequently, the writ appeal is dismissed.
Item number 56.
May I please, your lordships? My lord, the appellant has challenged the impugned order of the Honorable Single Judge under Annex 8, my lord. The background of the case is like this, my lord. The respondent number 3, the ST portion, my lord, ST community. The respondent number 3 wanted to sell a piece of land, my lord. He applied for the
prior permission.
Prior permission was accorded under Annex 4, my lord. Thereafter, the registered sale deed had been executed under Annex 5 in favor of the appellant, my lord. In 1997, my lord. Thereafter, in 2003, my lord, in a suo motu review proceeding, the respondent number 1 restored the case land in favor of the respondent number 3, my lord. On the wrong finding that the vendor is the ST person, he has three sisters. They have also right, title, and interest in respect of the case land, my lord. The Hindu Succession Act is not applicable in respect of ST, my lord, as per section 2(2) of the Hindu Succession Act, my lord. As such, my lord, ST women have no right at all, my lord. With that wrong finding, my lord, the respondent number 1 restored the castleland of the appellant in favor of the respondent number 3. And honorable single judge has also came to that finding, my lord. At your lordship,
The single judge has remanded it.
remanded but with the wrong finding, my lord. This is the wrong finding. I am taking to your lordship to.
No, consent of other family members. It's not about succession act. Come to para 5.
Yes, my lord, para 5. Considering the rival contentions of the parties, this court finds there is no dispute to the fact that the family consisting of the vendor and 3 sisters had in all total 9 acres and odd land. There is also no dispute that there is no partition involving the disputed property by the time of the sale involved. Further looking to the family structure, this court also finds there is no doubt that
this is self-acquired. This is the self-acquired property of your vendor.
Ancestral property, my lord.
Ancestral property.
Yes, my lord. Ancestral property.
Forget Hindu Succession Act in that sense. If he is died intestate, anyway, all the children have to inherit. If the father died intestate, the children have to inherit equal shares.
Only male person, not female person.
No, where do you,
yes, my lord.
Where do you get that?
Para 55 of this judgment.
All right.
The matter has been remanded.
In case of Madhu Kishore, my lord.
Madhu Kishore, sir. This is which tribe do they belong to? You have to prove, tribe. Not judgment. You have to show the custom of that particular tribe.
My lord. This honorable court has also in one second.
Simanchal Patnaik. Now, which tribe
is a non-scheduled tribe, man. I am the non-scheduled tribe. That is why permission.
Non-scheduled tribe means what? I don't know. You're not an ST.
Not an ST, my lord. I am the general person, my lord.
Then all the more, sir. Then why will the act not apply?
Section, your lordship may kindly see Hindu Succession Act, section 2(2).
You're not an ST.
No, I am not an ST, my
lord. No. Your vendor.
My vendor is an ST.
So which tribe did he belong to?
He belongs to scheduled tribe.
Which tribe, sir? Because Madhu Kishore is the Oraon tribe.
My lord, there is no dispute that it is a transaction which is hit under the regulation 2. He is bound. Only thing is that there are 4 co-sharers.
No. He says he should be arguing, which he's not arguing. Under the customary law applying to that tribe, maybe the sisters do not have a share.
No, that cannot
that
be.
Is my case.
No, this is the case.
Let us see.
He's trying to make out the case that there is this one son and 3 daughters.
Yes.
The entire property of the father will go only to the son. I don't know which tribe has that custom, but you can show. It has to be proved as a matter of law.
Scheduled tribe. All scheduled tribe.
Not all scheduled tribes, sir. Each tribe will have its own tribal customary law.
Section 15 of the Hindu Succession Act, it is applicable to
Hindu, all right. See, if he is able to show that the tribal customary
that cannot be proved.
You have to make out a case, you have to prove it, sir.
Let it be taken up tomorrow, man. Yes, ma'am. I have a case, man, because I have also so many.
Is remanded.
You prove all that before. We'll say that notwithstanding this observation.
That finding should go, my lord. Otherwise,
all right, not finding. We'll say we'll permit you to prove this.
And your lordship, kindly be here for 2 minutes, my lord. This honorable court also in one judgment, my lord, passed one order. Once the sale deed is executed, title passes away.
Sorry?
And that once the sale deed been executed, consideration amount has been paid before the registrar, then it becomes final, my lord. And
if there is
violation of
that is not
46, that no such sale deed can be.
Don't make that submission. Here is a case, there is an infraction of law.
Correct.
The law has not been followed. So even if there is a
challenge in the present writ appeal is to an order dated 23rd November 2017 passed by the learned single judge, disposing of writ petition civil 5416 of 2003 filed by the Present appellant. Setting aside, and by setting aside the order passed by the order dated 14/2/2003 passed by the Collector Rayagada. OSA TIP review case number 135 of 2001 and remanding the matter to the collector to take a fresh decision in the said case after giving opportunity of hearing to all concerned and in the event of necessity of notice come out to the sisters of the vendor of the present appellant. Paragraph. The background facts are that the vendor of the present appellant belonged to a scheduled tribe bracket ST. He sold land to the extent of AC 0.27 decimals to the appellant. Pursuant to the permission granted under the Odisha Scheduled Areas Transfer of Movable Property, by Scheduled Tribes bracket Regulations 1956 on 5th December 1997. Stop. A sale deed was also registered on that basis. Stop. Subsequently, the collector Rayagada exercised suo motu powers of revision under Regulation 3 of the regulations and declared the sale to be void for the reason that the three sisters of the vendor also had equal rights over the land that was sold, and they had not been involved in the process. Paragraph. In the impugned order, the learned single judge has observed that since there was no consent of the sisters in the sale involved, the competent authority who granted permission should have first taken the consent of the sisters or afforded them an opportunity to be heard. It is in those circumstances that the matter was remanded to the collector. Paragraph. Learned conference sought to contend that under the customary law governing the petition, the appellant's vendor, the three sisters of the vendor would have no right, title, or interest in the land in question. However, it is seen that the appellant has not been able to plead any such customary law at any stage of the proceedings. Full stop. It is then submitted that in view of the observations of the single judge, the case of the appellant might be on remand before the collector. The matter is not still taken up in remand.
Not taken up, my lord.
For the last 5 years.
My lord.
There's no stay, nothing.
Status quo order is there.
When did we pass status quo order?
It was first last page 31, my lord. Last 2 lines, 4 lines. As the petitioner is enjoying a status quo order involving the disputed.
No. In this court.
With regard to proceeding of the case before the Rayagada collector.
No, no, this court granted no stay.
Appeal, there is no interim order.
In this court, there's no interim order, sir.
There is interim order that is also reflected in the last.
By this court, sir. By this court, there is no interim order.
No, my lord, no interim.
Last 5 years, the matter should have proceeded before the collector.
Because soon after passing of the order of the single judge, my lord, we prefer appeal.
So automatic stay. I think there is an amendment in the constitution somewhere. We have failed to read it. I keep asking counsel many matters.
Yes,
They say the minute something is filed in the High Court, automatic stay. And all counsel agree on that. So Orissa Bar has understood the constitution differently.
Yes, sir.
They have understood differently. Anyway, we are just, because all this long order should become meaningless if the collector has already passed a fresh order. We'll be wasting our time passing all this. What have we said? In the remand proceedings before the collector, paragraph, it is clarified that it will be open to the appellant in the remand proceedings before the collector to plead the items of the customary law governing the ST to which the appellant's vendor belonged. It was the three sisters of the vendor would have no right, title, or interest in the property in question. We'll stop. Paragraph. It must be noted that there is no stay granted of the impugned order of the learned single judge by this court in the present appeal in the last 5 years. So therefore, the above directions and order would operate only if the remand proceedings is not already concluded before the collector Rayagada. Full stop. The appeal is disposed of the above terms.
Supplementary list item 57.
None appeals dismissed.
Item number 58.
After service of notice to the respondents filed, the impugned order is at Annexure 7 series of the learned single judge that by the order dated 19/12/17 that read petition has dismissed my lord, and the prayer is rejected, stating that is a private contract and to seek appropriate forum. But my lord, prior to this order, my lord may come to page 34. The learned single judge are admitting the case on
that may be, sir. Still, you have to satisfy the court on maintainability.
But the relying three decisions that the in the case of ICICI Bank and versus Prakash Kaur, 2007, volume 2, SCC at page 711.
No, here, what is the bank here, sir?
That is that is your respond number 3.
Yes.
Fact matter for some deferred loan dues, the vehicle has been seized by the respond number 3. That has been challenged in the writ application.
Yeah, writ petition you can't have against Tata Motor Finance. You can't have writ petition, sir.
Well, can turn to page 34 of the learned single judge order.
Yes.
Page 34, where while admitting the case, notice was issued to the opposite party, and by an interim measure, there is directed that on depositing a sum of rupees 50,000 only within a week, hence before the opposite appropriate authority, no third party interest shall be created in respect of the vehicle of the petitioner bearing register number so and so. That is according to the petition, right? Annexure 8, the petitioner deposit the cost to the financier, and without going through the details of this order, my lord, this writ application was and by order dated 8/11/2009, my lord, sir, issued notice to the respondents.
It's all right, sir. Against a private financier, you can't have a writ petition. The writ petition of the...
But my lord, kindly have another decision, the contrary view was taken by the learned single judge in another writ petition that was being disposed of, directing the petition, concerned petitioner and the instant petitioner to deposit the 50%.
It's not a final decision, sir. It's only an interim order.
This helps and judge has practiced.
It's not an interim order. It does not decide the issue of maintainability.
But my lord, sir, I can turn to this order of the learned. The same judge and the same cause of action has disposed of the matter, my lord. The self-sense issued, my lord, relying the three decisions of the Honorable Supreme Court, my lord. This case was disposed of considering the willingness of the petitioner to deposit 50% of the default outstanding dues involving the default EMIs, directed to approach the concerned financier to get release of the vehicle. This is the.
It's okay, sir. These don't create a precedent. These matters don't create a precedent. It's all like equity. By the impugned order dated.
Only approach the concerned respondent number 3 is my lord, to get release of the vehicle.
That you're approaching the financial will, nobody's going to stop, sir. You can always approach.
After notice, they have appeared, but today is absent in the court, my lord.
Yes, can't help it, sir. By the impugned order dated 19/12/2017. Writ petition civil 22019 of 2017 filed by the present appellant against Tata Motor Finance Limited. Bracket respondent number 2. Finance Solutions Limited, bracket respondent 2, has been dismissed on the ground of maintainability by the learned single judge. Stop. Reference has been made by the learned single judge to the orders inter alia for the judgment in Scott Maruti Finance Limited versus S. Vijay Lakshmi 2012 1 SEC 1. Stop. This is indeed the consistent position that has been settled in a large number of decisions. Full stop. The court is unable to find any error having been committed by the learned single judge. Paragraph. It is then contended that initially, while issuing notice in the writ petition, the learned single judge had required the petitioner to deposit 50,000 with the private finance company, which it did. Full stop. The fact remains that it was and did not decide the issue of maintainability. Paragraph. It is thirdly contended that it should be open to the appellant to approach the finance company for refacing the loan. Full stop. It is clarified that the orders of the learned single judge or this court would not come in the way of the appellant approaching the finance company for appropriate reliefs. The appeal is accordingly dismissed with the above observation.
Let's say observatory dispose of.
It's fine.
Take a.
All right.
Item 59.
None appears for the appellant. Dismissed.
Item number 60.
I am for the opposite party.
None appears. Dismissed.
Item number 61.
Item 61 may please your lordship. Well, this is the PS. This PL has been filed challenging the illegal tender notice issued by OP3 on 17 for construction of the market complex in front of SDGM quarter and inaction of the collector and district magistrate in lieu of the
report of the district as your lordship has called for.
In fact, that report has come. All right.
My lord.
Hasn't that report come? This has already been communicated. It says report of the SDGM they got received. Flag report. It's not cascade. Create a nuisance success. We'll take this into account, sir. Just read this report.
My lord, today morning I had taken first instruction that construction work is not going on for a long time. Only
Because of stay granted by the court, sir.
My lord.
Your lordship may pass final order on the basis of
The report?
order.
All right. All right. The report has been received from the SDJM. They've got stating inter alia that the residential office of the SDJM is at an audible distance from the shop rooms, and it would create noise resulting in disturbance during performance of the official work. Full stop. The SDJM Devgarh being the cognizance taking magistrate, number of accused persons are being forwarded even on holidays and beyond office hours, and there is no open space available in the vicinity except in which the shop rooms are under construction. Full stop. It is stated that the advocates, litigants, and officials may face difficulties. Full stop. Accordingly, the district judge Devgarh has opined that, open quotation, the construction of 2 shop rooms in front of the quarters of the SDJM Devgarh would create nuisance. Unquote. The sketch map has also been enclosed with the report. Full stop. The report and the sketch map be placed on record and will form part of record of the present writ petition. Paragraph. In view of the above report of the district judge, the court makes the interim order passed by this court on 5/2/2018, staying further construction of the market complex in front of the SDJM quarters in Devgarh. Absolute. So, in other words, there shall be no construction of shop rooms in front of the SDJM quarters, and whatever construction has been made so far will be removed forthwith, and any event not later than 4 weeks from today. The writ petition is disposed of.
Your lordship may record my
All right.
municipality.
Item number 62.
Item 62.
Please, your lordship. This is regarding the menace of fake medical practitioners in the state of Odisha.
My lords, as per the last order, my lords had asked the state to
file an
affidavit with regard to the status. My lord, the affidavit has been filed yesterday. I'm supplying the hard copies.
You've furnished a copy to him.
I'll serve a copy.
I'm on behalf of the amicus curiae, Mr. Gautam Mishra.
Oh, I see.
I'll serve a copy on it.
Copy of the affidavit filed today by the state be served on Mr. Gautam Mishra list on December 21st.
Grateful.
Item 63.
May I please, your lordship? In this case, the petitioner filed this case for my lord removal of the unauthorized encroachment from the my lord railway land by the opposite parties, my lord. The petitioner, my lord, approached before the my lord opposite party not to.
So you not made the encroachers party.
My lord, 1107 encroachers.
Then what do we do?
Page 8, my lord, the collector has given assurance to the railway authority to vacate the, my lord, encroached land, my lord. Page 8, my lord.
So this will create huge chaos, sir. This is the whole problem. You're coming through PI like this, you're going to create huge chaos. There are encroachments by spiritual organizations, everything.
Yes, Lord.
So many temples.
14 numbers of temples, my lord. Yes. Temple. And 1107 individuals, my lord, encroached.
Then imagine giving each of them notice.
They have already noticed, my lord. Page 8, my lord. The authority already noticed, my lord.
No, but then what is the proceedings pursuant to such notice? We don't know that. How many of them claim they have right title interest? We don't know all that. We can't presume.
But the railway authority supplied all these, my lord, encroachment, my lord, they have made by the encroachment as page, my lord, 14, annexure 4, my lord. The railway authority provide the information, my lord, under Act, my lord. Unauthorized encroachment, they have already, my lord, given, my lord, the name.
Which is your representation, annexes 2 and 3?
Yes, your lordship.
All right. But that is again to the railway authorities, right?
Yes, your lordship.
No, who will remove the encroachments? Not railways.
Well, because by page 8, your lordship, the remark column, the assistant collector and district collector Rayagada requested the railway to give some time to vacate the encroached land, my lord. They have already assured, my lord, the railway. Page 80, annexure 1, remark column.
District administration not by the railway.
No, requested the railways to give some time to vacate.
Yes, your lordship.
That is, who is going to vacate? The collector. The district collector was going to take steps to vacate.
The Tahsildar, your lordship.
No, but have you not? You're not made the representation to the Tahsildar.
Because, my lord, already step has been
taken. If step has to be taken by Tahsildar, then your representation must be to the Tahsildar.
But, my lord, it is after recommendation by the railway. Otherwise, they cannot.
Sir, the authority who has to remove the encroachment is the Tahsildar.
Yes, remove the Tahsildar.
Then you should make a representation to Tahsildar, then make the Tahsildar a party, then we can ask the Tahsildar questions.
I
withdraw the writ petition and make, first of all, representation to the proper authority, sir.
Yes, your lord.
Counsel the petitioner seeks leave to withdraw the present petition with liberty to make a representation to the proper authority in accordance with law, and after following up on such a representation to seek appropriate remedies.
Yes, sir.
Disposed of as withdrawn with liberty is prayed for. All right. All right. All right.
Supplementary list item 64.
64, 5 restoration matter. No instruction matter.
No instructions dismissed. All right.
Item 65.
May it please your lordships.
Yes.
Yeah, my lords, coincidentally, the month in which this writ petition was admitted, the same month, my lords, it has been dismissed. Lords will kindly see, on 16/8/2019, the writ petition was admitted. And it on 17/8/2022. My lords, the counsel who filed this application was he joined as a member of the State Consumer Forum. Probably this
is there anything surviving in the main writ petition?
Everything is surviving.
I see.
It's a very lordship, here the undisputed facts before lordship is the petitioner before lordship is government of India undertaking who is engaged in this import and export of. Now in the export of goods, he receives DPB license, which is known as duty entitlement passbook. Now, this is given by the Director General of Foreign Trade.
All right. For the reason stated, then the applications allowed in the order dated 17th August 2022 is recalled. And writ petition civil 2035-2013 is restored to file. Full stop.
Lordship, identical matters is pending, and that has been posted on 23rd, Your Lordship, that is the order, 23rd November.
All right. The main writ petition is a list on 23rd November, interim order to continue.
Can you supply me the number?
Yes. The 10,865.
Yeah.
Magnum C
list on
10,000.
No, this is not of MMTC.
No, MMTC. DEPB
Point is
license
identical. So
levy,
you've got similar matters.
levy of purchase tax on DEPB on the same issue.
I'll check up that.
Yes. So list along with
My lords,
1065-2013 on 23rd November. Interim order to continue.
I'll only pray one thing. I was enjoying an
I said interim order to continue. Sir.
Yes, ma'am. Now the interim order, I have paid some amount and complied the order.
I know.
Lordship may kindly restore that interim order.
I have.
Much obliged.
All right.
Much obliged.
All right.
Grateful.
Item number 66.
66 I have already filed the second copy of the deed for stamp reporting. So let's me direct.
What's the matter about it?
My lord, this is a PIL matter. Second copy of brief was missed.
No. What is the matter about? Tell us.
Matter regarding the petitioner's claim. Community claims the status of scheduled caste. And
this is already dismissed. A very detailed judgment. That we have passed a detailed judgment only the other day. This is not a matter for the court at all.
Yes, sir.
No court can ask somebody to be included or removed from the list of scheduled castes.
Next
judgment. Please show me that.
I don't have.
Next, we have the judgment. They were cast. We've just passed that judgment.
Item 77 also same matter.
Already there's a judgment passed by this. You are not aware of the judgment?
No, I have not.
The other day, it's a long judgment, I say.
Next week, it may be taken up next week. So
No. What's the prayer in the present petition is for inclusion of the Radhi, Niari, NIARY and NIARI to be included at serial number 24 of the Constitution Scheduled Caste Order 1950 as synonyms of Devar, DEWAR. Full stop. This court has already rejected a contrary prayer for removal of single quotes, Kevta, Kaibarta, and Dibara, unquote, from the serial number 24 on the ground that neither inclusion nor exclusion of communities from the list of scheduled castes in the Constitution Scheduled Caste Order 1950 is permissible at the instance of a court, relying on the judgments of the Supreme Court in so and so. Consequently, the writ petition is not entertained and is dismissed. Just pull out that judgment.
Item 27 also, my lord, same prayer.
Yeah, I think you will have the judgment.
My lord, item 77, I have also for the petitioner.
It is item 66, my lord. Is the PIL?
Yes, we are rejecting it.
Yes.
The same prayer has been rejected by this court already. Yes. This covers item 24 also, is it? No.
77, my lord.
77.
77, my lord, the subcaste, that is Jiringira, Jingira. All these are mentioned in the cost.
My lord, 77, I may be given the, so that I will verify the judgment and place it, my lord.
Judgment, you can verify details of this very bench has passed the judgment. So it is very clear.
One day time may be given to.
No problem. So you get many more days. No problem. You just read the judgment, you will know it. Yes.
My lord, one day time will be sufficient.
It's all right, sir. It's all right. Thank you. Yes.
My lord, in item 77, I am appearing for the opposite parties, my lord, Union of India.
All right.
Item 67.
Mr. Jena, you have to unmute. Yes, please. Illegal construction of community hall.
Unmute yourself, sir.
All right. The petitioner's representation dated. What is that to show it was delivered? The representation's proof of delivery is not there. Mr. Jena, please unmute. Mr. Jena, kindly unmute.
My lord.
What is the proof of delivery of the representations?
My lord,
shows proof of delivery.
That is annexure 5, my lord.
No, but there is no seal. There is no seal of the receiving officer, sir.
My lord, your lordship kindly have a glance to annexure 5, page 17, 17, in the last portion.
I see. All right. The petitioner's representation dated 6th August 2022 will be examined by the district education officer, Baleshwar. And after issuing notice to the... But where have you named the encroachers, sir? You have not made them parties.
Video, Jaleswar. Yes,
No.
my lord, I made party, opposite party number 3, block development officer. Party number 3, my lord.
He's encroaching.
He has his park order for construction of the community hall that is there at annexure 3, my lord.
No, but whose instance?
Instances, because that is the work of the government. So instances which behind that may be surplus, but that is not indicated there, man. The local political people are doing that.
No. You say that Gabargata Panchayat Authority, but you have not made that Gabargata Panchayat Authority a party. Come to para 4.
My lord, they are not coming to the pictures because the video has issued work order by annexure 3, my lord. That's why I have made party to the video.
No. You have made an allegation in para 4. You have named the party.
My allegation, but the construction is going on.
You cannot simply make an allegation without making the person a party, the entity a party.
My lord, DO is there to look after the...
No.
So I have filed a representation to them.
All right, you say after notice to the Gabargata Panchayat Authority, the petitioners and after giving them a hearing, a reasoned order shall be passed not later than 6th February 2023 and be made available within a week thereafter.
My lord, in the meantime, the consensus should not be met.
No. It will be open to the petitioner to seek appropriate. No, let's not stop all that. It's all right. Yes.
Item 68.
Yes.
My lord, kindly taken up next week for removal of defects.
No, what is it? Achha, defects be removed within a week list thereafter.
Item 69.
Lords. Well, last time I had taken time to file the receipt showing the service of the sufficient of representations. Just I am submitting, your lordship. Though the stamp is there at page 37, it is not legible. First page. In first page, your lordship bottom, the receipt is there by OP number 1 office at page 37, 25/7/2022. And it's same.
All right. See the petitioner's representations. Dated 25th July 2022 and 9th September 2022 shall be examined by the collector Novapada.
That is OP number 1, my lord.
There is a director rehabilitation and resettlement.
All right. By the director rehabilitation resettlement.
Water Resources Department.
Come Joint Secretary Water Resources Department, bracket opposite party number 2. And after notice to the petitioner, as well as opposite parties
6 and 7, man.
6 and 7, is it?
There is a NGO. That NGO has been cancelled by annexure 1 series
6 and 7.
since long.
All right, 6 and 7. And after giving them a hearing, the reasoned order shall be passed not later than 6th February and be made available to the parties within a week thereafter. The court clarifies it as expressed no in the matter.
Item number 70.
May I? No delay. There is no delay.
All right.
I have prepared a short date chart, my lord. The direction has been given to regularize the service. Only difficulty, my lord, that after recruitment, one person has been appointed, and there is only one post. Against that sanction post, that appointment is on 1/11/2017.
But now, anyway, you've abolished contractual system, sir.
No, that contract system has been abolished in respect of those who are appointed in accordance with that contractual appointment rules. Your lordship know that.
No, now everything goes, no? There's no contract system at all.
This person will be on regular appointment. That appointed in 2017 will come to that regular establishment in view of that abolition of that contract system.
Then?
But the man who was appointed, he was appointed on DLR basis. Another person here, after facing the recruitment test, he has been appointed on regular basis on 1/11/2017.
You say on against sanction post on contractual basis, you say?
Yes, that because at that point we are following that contractual appointment after 2013. So post is one. That has been filled up on regular after recruitment process, my lord.
All right, you say notice returnable. Is there a contempt petition?
Yes, my lord, there is a contempt petition that CNTC number 3006 of 2022.
All right, returnable 12th December. There shall be stay of the impugned judgment till then. Defects be cured in the meanwhile.
Item 71.
71, my lord, there is no delay, though it has been pointed out by the registry. Let's kindly have this. I applied for the certified copy on 15th and received it on 20th. The appeal, the impugned order is passed on 8th, the 8th of September, and the present appeal has been filed on 11th of October.
All right, counsel for the appellant states that there is no delay in filing the present appeal. Tell us what the matter is about.
My lord. The registration has been and by the registering authority, and I've been successful in the appeal. I approached this honorable court. This honorable court is of the view that under section 44 of the Transfer of Property Act, a co-owner cannot transfer. That's the case, man.
Yes. So, what do you have to say?
Well, that is not the law. I can transfer. The transferee will step into my suit. Lordship can have 44, section 44 of the transfer. May I please?
No, but you don't have a right to alienate specific parcel of land. That is correct.
No, that is also not correct, because that the judgment says that even if I alienate a specific portion of land, the vendor, the purchase through me will not going to get the same parcel of land. Ultimately, whatever that is the declared law of the Honorable Apex Court, and I have relied upon those judgments. I have a copy of the sets of judgments with me. All these judgments, and including now and its registering authority is basically doing an administrative work.
No. It creates huge confusion, sir.
No, my lord, that
creates huge confusion.
My lord,
in fact, multiple litigation starts because of these kind of things.
No, my lord, lordship can have that 44 first. Where one?
Yes.
where one of the two or more co-owner of a immovable property legally competed in that behalf to transfer his share of such property or any interest therein, the transferee acquire as to such share or interest as so far as necessary to give effect to the transfer, and the transferor's rights to joint possession or other common or part enjoyment of the property, and to enforce partitions of the same. Now, my lord, even rule section 31 of the Registration Act has also dealt with them. It allows that transfer. The rule obligates that wherever there is a part transfer, that I have to give the specific details. And in the deed, I have said that it will not impair the right of other co-owner. I am in possession.
Please. So come to page 23. What is wrong in this? The reason for refusal. Just see that.
My lord. The vendor has mentioned the exact plot detail of the property and they wanted to sell. Well, that is, I am obligated under the law to do.
No. Since it is not a partitioned property, how do you know this is exactly falling to your share?
No, I am not saying that it is falling to my share. What I am selling, I am showing. I am not saying that it is my share. Well, what I am selling is...
No, you can only sell your share, sir. You cannot sell anything else.
This is undetermined because even this portion which I am selling, I have a share. These portions which I am selling, since it's not the portion which I am selling also, I have a share. But specifically, my lordship, the question is that how I determine that is my share. Because that, I agree that, my lord, that will not going to affect the right of the other co-owners. That is my answer. And not that even the law...
So what is the total area of land?
Total area is a vast chunk of land.
No. How did you mention?
27 acres, my lord.
So what you're selling is 1.490 decimal.
Yes, my lord.
How did you arrive at this?
No, my lord. I am not the co-owner and I have given this.
No, but you can't say plot numbers.
Otherwise it cannot be registered because the obligations.
This is the conundrum. Therefore,
my lord, lordship, kindly see the registered deed I have annexed, the proposed deed. Lordship, kindly have that descriptions are clearly mentioned at page 58.
No, that's also landing you in trouble.
No, my lord. The law is this, my lord. If I have sold something which is not ultimately fallen to my share, my vendee will not going to get that. That's the law. That's how answered by the Honorable Apex Court and Punjab and Haryana, full Punjab and Haryana High Court. And the job which the registering authority is doing is an exclusively administrative job. The effect on vendee has also been stated in the deed itself. I have stated, I have not suppressed anything.
Examine the question of law. Or notice returnable.
Well, all the state authorities and this is
only state
authority. I will give them the extra copy if you will.
But your vendee is not.
Vendee is
not a party.
Not a party, and he is not disputed.
But he has to be.
Yeah,
it's a company.
He has paid you money for this property already, or is not?
It has not exchanged, my lord, because it has stalled at the stage of registration. And I am being in legal necessity. I am coming before your lordship.
Notice returnable 31st January. All right.
Lordship, will a little bit early date because I am in legal necessity for which I am selling it. And all the state authority and whatever your lordship will decide, it will be have a far-reaching impact.
5th December. All right.
Great. Obliged.
Item 72.
It is ready for hearing, my lord. is ready for hearing, my lord. Paperwork is also prepared. So
No, 1182 of 22 has been filed for bail.
yes.
Where is the concept? Anyway, pass over.
Item number 73.
In item number 73, my lord, I am appearing for the respondents, my lord, Union of India. And the short date may be fixed, my lord, for to receive.
No, who's the appellant?
I am for the appellant, my lord.
Ah.
Also, the notice for my lord with regard to respondent number 2 and 3 has not been sufficient.
No, she's appearing for Union of India, is it?
Yes.
Union of India, my lord.
No, but 2 and 3, addressee not known, addressee
My
left.
lord, I'll just point out the problem with why it has not been served. If your lordship should look at the cause title. Because those contracts have been over since, my lord, late 70s and early 80s. The contractors are no more with us, neither we know anything, but they wanted to serve notice through the principal employer, which is not possible, even we can't.
How is this writ appeal maintainable? This is in an award, right?
Yes.
Yes.
So award, then single judge deals with this on 227.
Yes.
Then now a writ appeal is not maintainable.
That point, my lord.
Not maintainable, sir.
Lordship may keep it to some other.
No. There's a judgment. We want ready. We have ready.
Here, my lord, twice
give it to me.
it has come.
All your, we are law researchers for all of you.
And I am obliged, my lord.
Yes.
Lordship may give me some time, my lord.
No. We give you judgment. We also give you time. No. One.
Only as a last chance, your lordship may
No.
Sometime let me.
Lunch hour for a counsel of your capability. Lunch hour is more than enough.
Bow down to your lordship.
In 10 minutes, you know what the judgment is.
Yes. Your lordship may next week. Your lordship may.
No. Lunch
or the first week of December, November.
2 o'clock. 2 o'clock.
2 o'clock will be, my lord.
No. Not at all, sir.
Because your lordship may see the.
We may need a day. You'll need only 10 minutes.
No.
We are very slow. We are very slow in all this, sir. You are like this.
No, not at all.
Yes.
I only.
No. 2 o'clock, sir. 2 o'clock. All right. Pass over.
Item 74.
Can your lordship call it tomorrow?
No, sir. No.
Another matter again.
No time. On this side, no time, sir. We are also very slow, very inefficient. So we'll take the blame for everything. All right. 2 o'clock.
There are about, my lord, 600 employees. Their fate is, my lord.
I know, but what to do? Let's see. Yes.
Item
Your lordship. My lord, this is a public interest litigation for the differently able students, specifically the deaf school of Cuttack, my lords. My lords, in Annexure D/6, page 9, the school
number 7, incomplete address, it's come back.
My lords, opposite party number 7 has appeared already, my lords. The school has appeared. My lords, here the state government has admitted at page 9 of their counter affidavit, that they are upgrading the school, my lords, in 2017. And today I have received an affidavit signed in August 2022. They also say that so far as other allegation is concerned,
they'll be shifting.
Please, that's the
two special schools to CDA Sector 10.
But so far infrastructure is concerned, they have done it. So we should be thankful for the state government. The second aspect, which is very important, my lords, after Right to Education Act has come, 5+3 and up to 10th, they should upgrade, my lord. The school is at 7th, still 7th standard. And this is a school free of cost. The students have been given education. And after 7, they are left no option, my lords. And they admit that they are upgrading, but since 5 years, they have not done it. Lordship may fix
What's the latest on that?
My lords, the secretary of the school has to submit a proposal. My lords may come to page 4 of that affidavit, my lords. I'm reading from the second line. The proposal for permission for opening of class 7 to 8 and allowing class 10 will be forwarded through the DPLAC. The proposal for permission for enhancement of class of any special school is forwarded through so-and-so to the government for consideration. However, the approval of the same will be decided by the government. In the case of school for the deaf Nuapada, the proposal for upgradation of the school from class 7 to class 8 and opening of classes up to 10 will be considered on submission of proposal by the secretary of the school the district social security officer. After the inspection, so and so, it is to mention here the school has not submitted the said proposal to the.
This is why, that's what that respond number 7 was important. Where are they? Are they appearing today?
Well, they had appeared.
Who was the lawyer?
Mr. Bola, my lords. I'll inform him, my lord.
So this is the only.
We'll call it after lunch. We can get him.
Yes, my lords.
Just
Yes.
get him. Yes, we'll come back up.
Yes, yes. Given since 2014 and 15, which I have annexes 6, 7, and 8. And recently, my lord, in the last week also, there is a fresh proposal has been given. I have shifted it to the new building.
Oh.
And my lord, it is the
we-
government's responsibility to give the proposal and take it forward.
If it's come last week.
Do you have a copy of that proposal?
Yes, my lord, annexure. Yes, my lord.
No, the latest.
I am appealing for the headmaster and my lord, it has been annexed.
Annexure 6 at page 32.
That's a proposal 2014.
Yes, my lords, my lords. And recent.
14.
And now with this new location, there has to be which my learned friend is adverting to, that there is a new proposal last week, my lord, which has been submitted.
Recently, a fresh proposal has also been given.
If my lord, that is the case, then we'll take a call.
You say, as far as location of the school for the deaf is concerned, the letter dated 17th May 2022 of the collector confirms that it will be shifted to the new constructed integrated infrastructure complex building at CDA Sector 10, Cuttack soon. Paragraph. As regards upgrading the school up to classes 12, 10, up to class 10 is concerned, the proposal stated have been submitted by the school recently.
The secretary of the district social welfare, who is the secretary, who is the honorary secretary of the organization.
This proposal stated to be submitted by the district social welfare officer, who's the honorary secretary of the school.
Yes, ma'am.
Recently. Don't know the date, is it?
My lords, that they can only say, because he functions under the collector.
Should be examined by the by whom?
Well, it is to the district level project appraisal.
Your lordship may repeat it so that we can get that proposal also. The date exact, so that your lordship, it will be easier for them to also. Exact date of, because only we have heard that it has been sent last week. If your lordship may keep it to day after
All right.
tomorrow also,
You
we
just
can
say,
get-
simply say list on. All right. Simply say list on 1st November.
Yes.
Let's see it on
Lordship, I
1st.
kindly direct my learned friend to get that proposal, because it is government who has to give the proposal. We cannot, my lords. We can get the instruction at least, my lords.
Okay.
So that may be reflected in the order, because that is why matter is getting delayed. My
No, if you have a copy, then you can
lords. We
submit it.
cannot get a copy. We have to file an RTA application. He can get it easily. That is what, at least for the deaf students, my lords, he can get
All right.
it.
Counsel for the state informs the court that he will inform that the latest
proposal.
right. You see, on the next date, the counsel for the state will inform the court on the present status of the proposal submitted for upgrading the school for the deaf at Nuvapada
My lord.
up to class 10.
My lord. Deep blue bless.
List on 14th November. Then.
14. Great. Great.
All right.
Item 73. Item 73. Sir.
Madam,
Ah,
Madam,
ah,
I have gone through that judgment, my lord.
ah,
The paragraph 59 of that judgment, my lord.
ah.
That says, my lord, it is the court has to see whether the matter has been decided under 226 or 227. Well, I was seeing the judgment of this single judge. You'll also see the judgment at page 11, internal page 11 of the judgment. The judge
decided that matter under Article 226, keeping the settled position of law with regard to the issuance of writ certiorari by exercising the writ jurisdiction under Article 226 of the Constitution, and on meticulous examination of the impugned award, this court finds that the learned presiding officer has dealt with the all legal factual issues which germinate from the pleadings of the respective parties, basing on the evidence adduced before them, both in the as well as in a meticulous manner, by keeping the settled position of law in view of the pronounced by the apex court in referred to by him in the impugned award itself. The tribunal has gone into the depth of the issue, both legally and factually, dealt with the same reasonably. The petitioner having failed to make out a case about such and such. Last also, my lord, it is this court is not inclined to interfere with the impugned award in exercise of the jurisdiction under Article 226 of the Constitution of India by issuing a writ of certiorari.
Anyway, all right.
May I suggest one thing, my lord? Can it be remanded back to the single judge so that let it be decided under 227 within a specified period? That will, my lord.
So many.
Your lordship, 3 months, my lord. I am ready to, my lord. It will be, my lord, doing justice to the case, my lord, because 600 some employees are concerned. My lord, I only for them, and this is a pro bono case, my lord.
No, but the single judge decided it on merits. It's a detailed judgment.
Yes, under 226.
Whatever. So it's okay. Now that he's decided it. Now that he's decided it.
No, your lordship wanted to know that if it is under 226.
No, if it is 227, writable is not maintainable.
Yes,
226, it is maintainable.
Yes.
So anyway, since he has said it is 226, we can't change that.
Or you can remind.
Otherwise, also, my lord, as on date, if it is reminded, the single bench cannot hear because as per the roster, it has to be again a division bench. So it will be the same exercise, my lords.
It's pointless. So we might as well proceed on merits, sir.
Sir, on merits, sir, I request your lordship to give me some time to break.
All right. Counsel. Okay, we'll just record this. Counsel for the appellant points out that the learned single judge has decided the writ petition by the impugned judgment dated 27/10/2011 under Article 226 Constitution, and refers to para 9 of the impugned judgment paragraph. He accordingly submits that the present writ appeal would be maintainable even in terms of the judgment of the Supreme Court in
2018.
Just give that back to us. Paragraph. On merits, he requests for some time to address arguments at his request list on 14 December.
Much obliged.
Item number 75.
May it please your lordship. Your lordship, this matter, your lordship, there are 3 directives which are involved in this matter. At page 18 of the judgment, your lordship, judgment.
Yes.
First, may I make a small prayer, your lordship? I have got 2 other matters which are pending today. Can it be any other date than today? Because it will take a little time, your lordship. That is
all right.
Lordship already.
I know, my friend, I know.
Last occasion, requested for time, and there are 27 writ appeals pending because of this.
27 writ appeals pending.
It's 27 writ appeals.
Yeah, all connected to this matter, your lordship.
Same judgment has been stayed in this matter.
One judgment.
Already, my senior has already submitted the written note of submission. I have also submitted.
No, that's right.
In that light,
place the submissions. I am to place the submissions, your lordship, already.
How long will it take?
Your lordship, maximum half an hour, your lordship. Maximum. But any other day, because today I am there in another court, your lordship. A matter is fixed just now. Next week, any date, your lordship, make it.
The only problem is the board here is very tight, sir.
Yes. I know your lordship's inconvenience. That is why I am making prayer only. Only thing, your lordship, here what is involved is all the people, they have taken VRS. They have given all the VRS benefits also. Now 50% VRS benefits, they have been 50% compensation they have been given. They are demanding 100% on the basis of a superseded circular. That is the only crux of the matter. That your lordship is to see.
But my point is that if your lordship will see the circular, that guideline, that is a guideline, that is not a circular, and nowhere it is said that superseded. It is in addition to prior, sir. So that is the whole point. If that point is also very well analyzed by Honorable Single Judge. So in my written note of submission, same point, and in my learned seniors written note of submission of same point. Nothing more. Only it has to be disposed of.
Because why did you try 10 minutes?
That's all.
We'll get it done in 10 minutes. I'm sure you have a written note of submission. I'm sure you'll be able to conclude in 10 minutes.
My lord.
No, you already have a written note of submissions.
Yes,
So
there are certain decisions also which are required to be referred to. That is why I said maximum half an hour. That's why I submitted. Any day in the next week, your lordship, any day, your lordship.
All the decisions also, let's say, all the decisions are also analyzed.
Yes.
In the judgment.
That is why the appeal is here, whether it has been properly analyzed or
yes.
not. That's right.
Okay, you said the request of Mr. Mishra. Mr. Mishra, when did you give your written note of submissions?
He had already given you, lordship.
Oh.
It is there. First, my learned senior has given, then I also.
It is dated 10/12/2021. If it is there in your lordship's brief.
Yes, it is there.
Okay.
Thereafter, she has given your lordship.
Yes.
Sorry.
Oh, this one. Okay. All right. Where is it? I don't. Where is it?
Yes.
Correct. This is.
Your lordship gets it?
Yes. It's a date chart.
Date chart after that written note of submission.
Written submissions, your lordship.
Yes.
The heading is written submission with brief facts of the case and then submissions, your lordship. 7 pages, your lordship.
All right. We'll get it scanned. At the request of Mr. N.K. Mishra and Senior Counsel for the appellants, who is in some personal difficulty today. List on 21st November.
Yes. Grateful.
Item number 70. Supplementary list 76.
Every time it doesn't appear. No? Pass it over. Pass over.
Item number 78.
In 78, I'm appearing for the petitioner, my lord. This is the case with regard to installation of PET CT scan at Harrier Cancer Institute and other places in Orissa, my lord.
Correct.
So,
we have now opened the facility, apparently.
Yeah,
I am on behalf of OP number 3, on behalf of Mr. Panda. I have filed an additional affidavit yesterday that is on record with regards to the compliance, where I have also annexed the copies of the facility being inaugurated along with the and copies had been served, my lords.
Yes, I have also
filed an affidavit complaint complaints to Lordship's order, my lords, that I filed yesterday. So far as Acharya Hariyar is I've got the hard copies. May I give to Lordship the hard copies of this, sir?
All right.
As far as the state affidavit is concerned, which they have filed yesterday, I have also been served. Here I have one limited submission to make, my lord. If your lordship will see the order dated 12th of April 2022, my lord, I'll just read out the second paragraph of that order. Your lordship has got 12th of April order, my lord?
Yes.
Mr. A.P. Das, learned additional standing counsel for the state, needs some more time to update the court on the current status of procurement of equipment for the medical facilities at Baleswar and Berhampur. Apart from filing an affidavit regarding the above equipment in the above two cities, the state government will also inform by way of an affidavit to be filed 1 week prior to the next date of procurement and installation of similar equipment at Jharkhand and Bhubaneswar. Now what has happened, my lord, if your lordship will see the affidavit which they have filed yesterday, now they have taken a totally different stand, my lord. As far as Baleswar and Berhampur are concerned, what they have said, as per the order dated 12th of April, they have undertaken that they are already in the process of procuring the equipment. Now here they take a stand. They say that the building is under construction and it will not be feasible for them to install the PET CT scan due to the distance factor, which is just contradictory to the submissions they have made on 12th of April. So they have to be first clear as to what stand they are going to take, whether it's the distance or the construction. Accordingly, we can place the argument, my lord.
How come you've suddenly changed your stand on Berhampur?
Baleswar is concerned, we have stated that Baleswar there is no problem.
No, you have.
No,
just say, yeah. Hence, current situation, PET CT establishment will not be feasible.
At Berhampur,
No. Even in transportation of radioisotopes by road from Calcutta will not be possible. Unless Baleshwar is connected to direct flights. It will not be feasible for running PET CT scan. Just see page 4.
Yes, no.
You've suddenly given up both Baleshwar and Berhampur.
And for Berhampur, they have stated that isotope has to come from Hyderabad, which is 16 L. Why not from Bhubaneswar, my lord, which is just about 3 hours drive? Bhubaneswar has an airport.
But even Bhubaneswar to Baleshwar is just 3.5 hours.
Less than 3 hours.
4 hours.
So why can't it be possible?
No, first, they should be very clear as to what stand they're going to take. They cannot keep on changing stands, my lord. Once they made a submission before your lordship.
So far as Baleswar and Berhampur is concerned, I will take instruction. To that effect, I will file a different affidavit with regard to Baleswar and Berhampur.
I better you take this back then. You've already e-filed it. The other affidavit. All right. In the affidavit filed today, in the affidavit dated 18/10/2022 of the Special Secretary (PH) to the Government, Department of Health and Family Welfare, it's contended that because of the time taken for transportation of radioisotopes, PET CT scan function facilities cannot be made available either at Baleshwar or Berhampur. Stop. It is seen that according to the state authorities, the transportation of the radio to take place from Calcutta and Hyderabad respectively. And it is contended that till there are airports at both places, it may not be feasible. Full stop. However, the affidavit is silent on why the transportation of the radioisotopes cannot take place from Bhubaneswar to both places by road, as that would take not even
around 3 hours.
That would take about less than 4 hours. Full stop. Mr. Samantrayal, an additional government advocate, states that he will seek instructions on this aspect. and file a further affidavit by the state.
I submit one more thing, my lord. As far as the Bhubaneswar is concerned, they stated the para 5 of order dated 29/4/2021 as regards establishment of similar facility at Capital Hospital, Bhubaneswar and Jharsuguda, it is stated that the facility at the aforementioned two local locations will be made operational by April 2023. But now 1.5 years has been passed in the meantime. Now today they have another 2 years of procurement of bed scan is required. That is also a vital point to be considered by your lordship, my lord. It already stated in their affidavit that it will be operational by April 2023. Now 6 months left. Now they have stated today that it will take another page 5 para 2, my lord. Today's affidavit. Plan and estimate for cancer wing at Capital Hospital of Bhubaneswar has been prepared and submitted by the Chief Engineer Building Administrative Approval for establishment of cancer wing at Capital Hospital, Bhubaneswar, has been accorded by the government. EFC approval is under process. Civil work would take nearly 2 years.
Further
procurement of PET-CT would be initiated once civil work is completed.
In respect of making the facility available at the Capital Hospital, Bhubaneswar, also be submitted along with the affidavit. Okay.
I may be permitted.
Much obliged.
I may be permitted to make
Look,
small.
right in the beginning, you say the court is informed that the PET-CT scan at the Acharya Harihar Postgraduate Institute of
I'm
Cancer
thankful for lordship that it
has already been inaugurated.
I have to make some small submission in this case, my lord. In this case, Maitri Sansad is a letter petitioner in this case.
Correct. We'd ask that.
But that reply they have not given.
No, so far as RDC reply not regarding that, I will file not that in the process we are trying to get it done. Of like
SGB. That at the SGB.
Yes, no. That affidavit I will file not by the next day.
I have to give a reply to my application which I have already filed.
Yes, I filed that.
I have my lord. I have also filed a miscase, my lord. Which
That's right. We've asked them to file to that miscase only, sir.
My lord. Oblige me.
Reply to IA number 11176 of 2022 also be filed before the next date.
Oblige me.
Much obliged,
Much obliged.
May I pray the state's affidavit may be served on us, it has not been served.
All right. Copies of the affidavit be served on counsel appearing for the opposite party number 5, right?
Three, my lord.
Three.
I'm for the opinion number 4, my lord.
4 January. 4 January. Sir.
Item number 79.
Please, your lordship. My lord, please to issue note MDC, my lord.
79, my lord, sir. We have received the paraphrase reply. I seek only further 2 weeks' time. Will be filing counter.
All right. At the request of counsel for the ITCO. No, counsel for the ITCO seeks and is granted for me to file a reply rejoinder for the next day.
My lord.
15 December.
My lord.
Supplementary list item 80.
May I please, your lords? My lords, I humbly pray before my lords for direction to the opposite party's concerned authority for initiation action against the encroachers who the opposite party number 5 and 6 have encroached the public road, village road of the petitioners.
This is filed in 2017. What is the change now?
My lord, the opposite party number 4 has been directed to appear in connection with the matter, and I have served copy on the Law and Council opposite party number 4 on 24th August 2022.
I am appearing for OP4.
What are the instructions?
There is no allegation against OP number 4.
No. You're not removing encroachers. That's the allegation.
Yes.
The property.
On your property, there are encroachers, he says, and you're not removing them.
My
lord, state government will remove them. The property.
Are you agreeing there are encroachers or not? You first tell us that.
Let me take it. On that, I will take.
Counsel for the respondent for opposite party.
The property will have admittedly belongs to Lord Jagannath.
List on 12 December.
12 December.
81. Item number 81.
My lord, item number 81, I pray 3 days time to remove the defects, my lord.
2018 defects, sir.
My lord.
What's the matter about?
My lord, this is a matter, my lord, where, my lord, the petitioners are challenging the notification issued by the opposite party number 6 for declaring the area as an eco-sensitive zone touching the boundary line of the Konarka Puri Balukhand Wildlife Sanctuary, my lord. My lord, what has happened, my lord? Here, my lord, by virtue of under Annexure 1, my lord, in the year 1984, my lord, under Section 18(1) of the Orissa Wildlife Protection Act, intention to create sanctuary was there, my lord. Thereafter, my lord, under Annexure
941 is something else.
My lord.
Let's kindly see.
1 minute. This connected writ petition 149.
My lord,
that has been in fact disposed of.
My lord, what has happened, my lord? I'm just clarifying. What has happened? The connected writ petition I have directed to list because, my lord, we are challenging the Annexure 1 and 2 in that application. What has happened, my lord? On the other day, I was not there. My mother was ill. I took her to Bombay for treatment, my lord. My associate mentioned for adjournment, but your lordship on the submission of the counsel for the state, my lord, stated that no issue survives since the notification is of the year 1984 and 87, my lord. What has happened? Though the notification
I'm just seeing what is connected.
My lord, connected matter 14941 of 2016, my lord. My lord,
so why have we put 18 there? 16 is over, sir. Now 18987. You tell us what the matter is.
My lord. What has happened, my lord? Here, my lord, the notification for declaring wildlife sanctuary was issued under Section 18 of the Wildlife Protection Act, my lord, in the year 1987, my lord. My lord, thereafter, as required under the Wildlife Protection Act, the forest settlement collector is to carry out the, my lord, inquiry under Section 19 to 25. Thereafter, final notification under Section 26A of the Wildlife Protection Act is to be issued and it has to be published in the Gazette for declaring the sanctuary. That sanctuary has not yet been declared, my lord. Without declaration, I'm taking your lordship. This honorable court has the occasion to declare that there is no sanctuary. Your lordship, I am relying on the
there's a counter filed already.
No, not been filed, my lord. And they have admitted, my lord, in other writ application.
No, the assistant conservator of forest seems to have filed a reply.
No, my lord, I have not received any copy, my lord.
That is, my lord.
No, that's in some other.
My lord, that is in the connected writ application, my lord.
No. 17885
of 2009.
2009, my lord. In that writ application, my lord, this honorable court, your lordship may kindly see page 99, the judgment of this honorable court. Where
petition number civil 14941 of 2016 need not be listed. It's already disposed of, I think.
My lord.
As it has already been disposed of. Then you say, the short point urged in the present petition is that the final notification declaring the
sanctuary.
Which sanctuary, sir?
My lord, Konarka Balukhand Wildlife Sanctuary.
Konarka Balukhand Wildlife Sanctuary has not been issued.
My lord. As required under Section 26A of the...
Despite Section 26 capital A of the Wildlife Protection Act.
My lord.
1986.
My lord.
1986.
Wildlife Protection 1972.
1972.
My lord.
All right. You say notice, Mr. Mohanty accepts notice for opposite parties 1 to 5.
We are from the opinion of 6 only. Others are
as well as 9 to 12. How is NHAI and all a party, sir? Why have we put NHAI and all a party?
My lord, I will delete my lord.
What about 7 and 8? Also, you will accept notice?
Puri Konark, I have to take it.
Mr. Party accepts notice.
This is to go, my lord.
Opposite party number 6. Notice to the remaining respondents. Returnable on the next date. You say the opposite party number 13 be deleted from the array of parties. And the consolidated cost title be filed within a week. In the meanwhile, defects be removed. On 5th January.
My lord, other
That 14941 of 2018 also need not be shown.
other two petition deleted from the
Deleted.
obliged.
Item 82.
My lord, I am permitted to appear on behalf of Mr. Mukherjee. Your Lord had directed the last time to the Odisha Staff Selection Commission to give the updated position regarding filling up of vacancies in police force. They have filed affidavit, but it is still 2019. I pray the updated list of vacancies vis-a-vis the steps taken may be filed. Better affidavit may be filed.
This affidavit, we have filed the updated affidavit since 2019 till today, whatever requisition made and selection process have been undertaken, that we have given. Right from 2019 to till today.
At the request of... No, you have already filed.
Yes, I have filed on 12/1. 12/10 I have filed.
That is from 2015 to 2019. But after 2019, how many vacancies have arisen? That
Thereafter, Police Selection Board is conducting the matter, not the requisition which we have received from the government. In that respect, I have given. Rest part government can say.
The affidavit filed by the OPSC gives the position of vacancies up to 2019 and not thereafter. Mr. Swine states that for the period thereafter, it is the state government that has to file an affidavit.
Government is to file.
Mr. Kuntia, appearing for the state, states that he will file an affidavit on the vacancy position, updated vacancy position before the next date. January.
Store matter. Item number 23.
May I please, Lord? I have given a date set in course of the day, my lord.
No, 23.
Item 23.
There, my lord, I am appearing for petition.
Petitioner. Aha.
Sorry.
Who's for the opposite party? You're there.
My lord, senior is appearing for bank.
Yes.
Date set is certain. In course of the day, I have filed.
Yes.
Let me see my date set.
So in that you don't figure.
Yes, my lord. I was not charge seated, but your lordship, on last occasion I have shown my lords that suspension order.
Right.
In that suspension order speaks only on the investigation of CBI. I was placed under suspension. Charge sheet was submitted by the CBI. In that case, my name did not find place. The entire case, my lord, the entire allegation is that FIR logged by the CA on the allegation of opening a fictitious account in the name of Subhash Chandra Samak. That is the entire case. And the criminal case ended in those 3 persons against whom 3 persons criminal case was logged. They were acquitted. They were reinstated in service. I was a witness in that criminal case. And your lordship, I have quoted the paragraph 10 and 12 of that judgment that was annexed. Lordship, kindly see my date set, because in that judgment that was not legible, so I have quoted it. Page 9, your lordship, see page 9 of my date set.
Right.
Moreover, it is evident from the evidence of a responsible BJP Keonjhar branch PW3 that he himself had seen account holder SC Samal in connection with the withdrawal of voucher dated 38 for rupees 10,000 Exhibit 24 has been marked in respect to the aforesaid amount as SP 1 of 89. The PW has deposited in that respect as PW 3 in that case. It is revealed from his deposit. From a deposition at paragraph 7 and from statement of PW 20 in paragraph 17 that PW 11 had stated before PW 20 that when the said withdrawal voucher was produced before him by one Subhash Chandra Samal, said SC Samal had again put signature there before him as he was entertained doubt on the existing signature. Thus, it is clear from the statement before the court that SC Samal was physically present before him and put his second signature on Exhibit 24. According to him, the signature appended on Exhibit 27 to 30 belonging to the said person as the specimen signature card. PW 19, who with the PW 18 in the speech 1 by 89, in the examination report marked in both the cases, has stated that the second signature marked by him as questions are similar to the handwriting of acute BD Saw, which is being negative in view of the opposite evidence of said PW 3, which PW 1 in this case, PW and 8 claim acquittance in respect of the handwriting and the signature of BD Saw. Still then they do not say that signature of SC Samal appearing in the Exhibit 27 to 30 belong to handwriting of by BD Saw. There is nothing to disbelieve PW 11 and 18 in this respect. In view of this evidence and materials on record, necessary conclusion that SC Samal, the account holder of SB account number so and so, is existing and not a fictitious person. Well, the allegation is that he is a fictitious person. I opened the account in his name, and I am a class 4 employee. And the very interesting part, my lord, the allegation that a seal was seized, that was seized after 2 years of my transfer. So on those allegations, I have been dismissed. And those persons who were charge sheeted by the CBI, they were acquitted and they were reinstated in service.
Yes, please.
That is the case only.
The reference to that criminal case, CBI case, that is in 2006. But here the proceeding was over in 92. 92.
No, but he was not named.
We are not confident.
Why?
To clarify Lordship doubt, could your Lordship kindly turn to page 50 of the brief?
Yes.
That is the crux of the matter. In fact, there are two branches. There are two branches of this Baita Rani Gramya Bank. One is at Soso, the other one is at Keonjhar. Lordship has come to page 50. That is what he's filed. Annexer 8 series. I don't know. I've page marked according to his brief. I'm not sure whether it tallies with the Lordship.
My Lord, senior is saying about read petition.
Read petition.
Ah, you're in the writ appeal, sir.
Yes. He was dismissed in 92. While he was dismissed in 92. Now 96 comes the criminal appeal judgment, that criminal case.
That's all right. The question is, he's completely exonerated as far as CBI is concerned. They don't name him as in the charge sheet at all.
Well, that was in another branch. This document which I showed to your Lordship was advice sent from Soso branch. Your Lordship sees the seal, round seal at the bottom, where he was working. And he was working as a messenger there. Now he was deputed to go and buy those, repair those seals. So he got 3 seals. Now this round seal he prepared. If your Lordship kindly see, the spelling is Baita Rini. RINI. Baita Rini Gramya Bank. Whereas the document says is Baita Rani Gramya Bank. So innocuously, this document passes through. A credit card was from Soso branch to the Keonjhar branch to encash it. And it's in the name of one Samal. While he was there, he issued 2 vouchers. He's no way concerned, but he managed it. And
so your charge is that Samal is a fictitious person,
yes,
and you have opened an account in the name of a fictitious person. This is your specific charge. You don't prove that. You're proving something else.
Charge was that he manufactured this passed on.
What manufactured what?
A seal.
The seal as a messenger. As a messenger, he put that seal, carried it to the bank, Keonjhar Bank. That's a credit advice. 19,000 odd. The next document, ME56. These two documents were presented and cashed. It was proved in inquiry that yes, it is his signature only. It is this man's signature only.
How do you explain the complete failure of CBI to charge sheet him?
CBI charge sheet was in respect of some other persons. The officers who allegedly opened the account.
No, but he is not named, sir. If he's part of all this, how come his name is not there?
We are not concerned with CBI case.
No, we very much. How can you now wash up your hands?
Page 16.
The whole CBI investigation happened because of your complaint.
Yes.
True.
How can you say you're not concerned with it?
No, that was misappropriation.
Whatever, sir, against this, under the same set of facts.
No, here in the department proceedings, the set of facts is that 5 debit notes were issued. ME5, ME6,
Sir,
ME7,
on the same
8
facts,
and 9.
the CBI investigated. On these very facts, the CBI took up investigation.
These documents were not there.
We don't know. I'm just saying on these very facts, CBI took up an investigation and has filed a charge sheet without naming the appellant as an accused.
True. That has got nothing to do with department proceedings. Both can continue simultaneously also.
No.
Based on different facts. Based on different facts.
Are these facts different? Not really being asked to you, sir.
Yes.
How is it different?
Kindly see the charge sheet. Page 18.
Yes.
Sri Kalakar Chakra got prepared a round seal stamp of the branch without any approval sanction. This round seal was found to be affixed on the forged credit advice purported to be drawn by Soso branch. Purported to be drawn by Soso branch and on Keonjhar branch. Charge number 2. Sri Kalakar Chakra have prepared 5 credit advice totaling 79,900 purported to be drawn by some branch, by Soso branch on Keonjhar branch, favoring one Sri Subhash Chandra Samal, a fictitious account of the branch.
Findings to the contrary, sir. The finding is there is no such, there's a real person called Samal. There's no fictitious person. That's how everybody else has got exonerated. They've been reinstated also.
But that is totally different.
Everything is totally different for you. It's all from the same set of facts. Of 3 same case, they've been acquitted.
No. Here, my lord, in the department of proceedings, the officers of the Soso branch, they were examined and they have proved that it is in his handwriting while he was there. ME5 and 6 were prepared by his own handwriting. That is the evidence of MW1 and 3. And he cross-examined them. ME7, 8 and 9 are those debit vouchers which were prepared by others, but through him. 86 he was transferred to Keonjhar. Now he was the messenger carrying these documents. So the charge number 2. Once a fictitious account of the branch, which was withdrawn subsequently from the said fictitious account, thereby causing heavy loss to the bank. The above act of misconduct are in clear violation of the clause so and so service rules. And here are called upon submitted written reply. So the inquiry officer found exhibits ME5 to 9 were issued from this branch. And that seal was found in the desk where he was sitting, discovered later. Now, 5 and 6 were in his own handwriting, which was testified in the department inquiry by the management of interests. In his presence, he cross-examined them. He didn't deny that. And one more document was proved that when the CBI inspector came, or the officer came, to find out who is this man, they went out to that village, and he also reported that there is no such person by such a name. Now, all this is over in 1992. The Department of Proceedings over 1992, the judgment after 1996 in the criminal case. And in the counter, I've said that we are not concerned with that. That's for a separate branch. Here, he had only put the seal only. He managed to carry that to the Keonjhar branch where it was encashed on different occasions. So exhibit at page 50, I've shown one. My lord may see that the difference between the voucher at the top, page 50.
Yes.
Page 50 at the top, Answer 8 series. Boita Rani, Gramya Bank. On the right hand column, Boita Rani, Gramya Bank. Whereas in the round seal, it is Boita Rini. In of course, it goes through. The bank encashed it. Next document also ME6. But at page 51, by then he was transferred. He had gone there. This was written by somebody else, managed by him, and this is also paid. Now, when the CBI found out that there is no such person, that document is Exhibit 21, which was confronted to him in the department inquiry. Now, the scope of department proceeding is preponderance of probabilities, not proof beyond reasonable doubt. And the inquiry officer had held that, yes, he was not authorized. He was sent for only three seals, which he prepared. This fourth seal was not authorized. So he has managed that, kept it in drawer. It was found out there. Now, after all the witnesses have been examined in department proceedings, and he has cross-examined them, what is the scope left after 4 years? 92, it is concluded. This 27,496, those officers of Keonjhar branch, different branch, they have been acquitted. They were charge sheeted. That is for the purpose of opening of account, closure of account, withdrawal, passing it. Those are different circumstances. Other documents, voluminous documents were exhibited there. But here we are concerned with only few limited documents which have been proved, marked in this presence. He doesn't deny them. Now he filed an appeal. His appeal was dismissed on 6/193. It was communicated to him, the appellate board. It was communicated to him, but after receiving that, he filed a writ petition. That is OJC 7065 of 93 before this honorable court. And he withdrew that, saying that no, I'll file an appeal, suppressing all these facts. And when after it was disposed of, under Annexure 9, he filed an appeal, fresh appeal. Annexure 11, he was replied by the bank that we have already rejected the appeal. So Annexure 11 stands no consideration. All this is transferred before 1994. This acquittal comes in 1996 in respect of some transactions, some withdrawal, who took the money, how it was passed through different stages. Those are three officers who are of different branch. And the scope of inquiry in this appeal, in a writ appeal, or the scope of inquiry by the honorable single judge is very limited on Article 226. It confines the materials on record, nothing else. By 1994, when he filed the 7065 of 93, he could not have taken these things. The so-and-so officer was there. Now, this is the second writ petition. And what is the ground? What is the scope of interference? Only if it's based on no evidence. If it's based on some evidence, the court will not interfere. Next is quantum of punishment. And quantum of punishment was not said to be harsh. The appellate authority also confirmed, you have been rightly dismissed. You managed the seal, put it, which goes innocuously. And the Honorable Single Judge has rightly dealt with all these aspects. The scope of dismissal proceeding and a criminal case are totally different. There, it is proof beyond reasonable doubt. But as far as criminal case is concerned,
you're repeating yourself, preponderance of probability. This is the third time you're telling the same thing, sir. Anything else? Anything else, sir? All right.
So
we'll reserve orders.
Orders. 96 order before the trial court. The single judge will only deal with what is there before him in the department proceeding and nothing more.
Pastor matter item 72.
Mr. Panda is either is not able to know that his matters are being listed. The other Passover matter is also his. 72 also he's filed this bail.
72 and 76.
Mr. Amulya Ratna Panda.
Always elusive.
Pardon me,
Mr. Always elusive, I said. Last time also.
Last time also he's found out. Even in 76 also number of times non-appeals.
Well, that's not in this matter, not in 72. Ah. What did the pastor want?
No, not.
Mr. Amuli Ratna Panda, who sought time the previous date, has not appeared today despite a Passover. In the connected appeal 181 of 2016, also none appears. Complete set of the paper books we provided to the Secretary High Court Legal Services Committee, in turn will engage a lawyer of not less than 10 years experience to appear for each of the appellants. The papers will be handed over to the assigned lawyer, who will try and get in touch with the appellants for instructions before the next date. 11th January.
Both the matters your Lordship is putting it in, John. Okay.
Item 76. Item 76 also.
Same order.
But in 72 matter, Ms. Dipali Mahapatra is appearing for other. Mr. Panda is for only appellant number 1.
But and none of them is here.
None of them is here.
76 is a different date, 18 January.
Hearing matter. Supplemental list for hearing item number 83.
May I please your Lordship? May I please your Lordship?
Yes. See, which item are you in, sir?
83, my Lord. May I pray, my Lord, at this hour of the day, 3 o'clock, 32 accused persons have been convicted. So,
no problem, sir. We have no problem starting. Please.
My Lord.
This has gone on and on. Mr. Naik, I think you're pushing your best. You're trying your hardest, Mr. Naik. I should compliment you for this.
I'll post.
Hats off. Hats off. Hats off.
I'll post my best.
We have to bow. We have to bow to you, sir.
No, sir.
The vast experience you're using to get adjournment after adjournment.
No, my Lord.
Remarkable. Remarkable.
No, my Lord. I'm glad.
One fine day it has to start, sir, and today is that fine day. Right.
This is a case, my Lord.
Yes.
Where 32 accused persons have been convicted under section 302, read with section 149, my Lord.
Yes.
27 Arms Act, and also 307 IPC, my Lord. 148, 302, 307, 25, 27 Arms Act, my Lord.
Yes.
The background of the case, my Lord.
Yes.
The dispute between 2 villages.
Yes.
One village is known as Sarkapur. The other village is known as Raghunathpur.
Right.
The dispute is for a very small matter. The dispute is, my Lord, they were disputing the respective boundary and from the boundary of Ghumsarpur, your lordship may keep in mind that Ghumsarpur belongs to the prosecution party's village, and Raghunathpur belongs to the accused person belongs to Raghunathpur.
All right.
Raghunathpur villagers, my lord, were not accepting that they were taking some soil, my lord, from their boundary, for which there was a enmity, previous enmity, not exactly enmity, my lord, they are opposing.
Right.
On the date of occurrence, my lord, it is stated that the sarpanch of both the villages, a sarpanch who belongs to under whose jurisdiction both the villages come, my lord, he has decided to settle the matter in village Ghumsarpur. In village Ghumsarpur, my lord, he has decided to settle the matter. So a meeting was convened. It is stated that a meeting was convened, my lord, and it is stated, my lord, 4 to 5 persons came, and 3 persons came first, my lord, and the sarpanch or the villagers, they insisted that some other persons, more persons or 2 persons should come. And here is there are some suppression, my lord, that these 3 persons were assaulted or insulted, for which, my lord, they went. Thereafter, the others came. Their story is, my lord, while others came to attend the meeting, they have come being armed with different weapons, my lord. One of them, my lord, Kulomani Raut, was armed with a gun, my lord, and others also, 2 to 3 others, my lord. They were also armed with some country-made pistol, etc. 4 to 5 persons were armed with lathis, and others, 2 persons, my lord, armed with a known as in our language, man, in Odia, it is known as tenta. It's a sharp-cutting weapon, my lord, piercing hand, my lord, pinpointed hand, my lord. So with this background, my lord, on the date of occurrence, there was a free fight. Some of the accused persons were assaulted, and some of the from the prosecution side, my lord, the deceased as well as some of the witnesses has also received injuries. And on the base thereafter, my lord, one hammer out during the course of being fired received a firing injury, gunshot injuries by Kulomani, fired by Kulomani Naik, my lord. Accused number 1, my lord, I mean the criminal appeal, my lord. 268, my lord. He is the appellant, my lord. He died at the spot. On the basis after, my lord, thereafter, my lord, a FIR was lodged. FIR and a counter FIR was lodged, probably, my lord. There is a counter case, but that has not been tried along with this case. But admitted case is, my lord, some of the witnesses, some of the accused persons have also received injuries at the spot, which indicates that there was a free fight among both the parties. So when a FIR was lodged, my lord, your lordship may kindly see, I have also given the English translation of the FIR. I have submitted before lordship also the copy.
Yes.
Translated a copy of the FIR. Respected sir, officer in charge, Baluga police station, sir. We, Devendra Torai, son of so-and-so, of village so-and-so, post so-and-so, PS Baluga, district Khurda, on 23/6/93, been present in police station, lodged this affair as follows. There was a dispute between our village and Raghunathpur, Lunuputtu, in connections with a government plot, Gochara land, which with the leadership of Lingaraj Pradhan, the Sarpanch, Lingaraj Pradhan is a witness, my lord. Lingaraj Pradhan, the Sarpanch of Yeswara GP, today a meeting for settlement was fixed. While our villagers were discussing the matter with the Sarpanch near the Jubaka Sangha office at about 9 a.m., the following persons, your lordship may kindly mark. Following, I am not reading the name, but reading one name at least, Kulomani Naik, my lord, who is the principal assailant. And by whose of hiring, my lord, one person's died, I must concede, one person's died. His name is Hamar Raut, my lord. In this case, only one deceased, and his name is Hamar Raut, and admitted case of the prosecutions, as stated by all the witnesses, as a finding of the court also, that Kulomani Raut fired a shot from his my lord, gun, as a result of which Hamar Raut died, my lord. Thereafter, my lord, Kulomani Naik, Jitendra Naik, Hajari Pradhan, Hajari Raut, Kartika Dholai, Digambara Swai, Lokanath Sahu, Madhu Lenka. Names are reading all the names, my lord, necessarily. But your lords may kindly see the total name is 56. 56, my lord, named accused persons. 56, my lord, lords may. how many? 56 named accused persons.
Yes.
With them, another 60 persons, my lord. So, another 60 persons of Raghunathpur Lunipata being armed with gun, thali, banta, lathi, knife, and stone in a bag, etc., attacked our villagers. From amongst them, the first 4 persons were armed with a gun, and the first 12 persons had put the helmets on their head. And therefore, Sarpanch Lingaraj Pradhan prohibited them not to create such circumstances. At that time, they had already come up to house of Rajkishore Torey, son of Gaurahari Torey. At that time, in the state of protest, Madhu Lenka, son of Mansingh Lenka, gave a blow on the head of the Sarpanch by means of the lathi, and the Sarpanch fell down on the ground. Sri Shama Rao, Madhusudan Torey, Mahendra Torey, Jenna Barik, Dasarathi Raut, Bhikari Raut, Harihara Torey, etc., went to protect the Sarpanch. At that time, aforementioned villagers of Raghunathpur said abuse like say some slang language, and what compromise you will do. We will finish you today. After abusing like this, Hajari Raut, names are there, my lord. So lords may kindly see the name. I'm counting, my lord. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15. Why I'm counting, my lord? Because 32 accused persons have been convicted. But here stated these 14 accused persons caused injury. It's important, my lord. 14 accused persons, these 14 accused persons, the affair story, my lord. These 14 accused persons caused injury. So, and the rest of the accused persons, my lord, although they have accompanied, there is absolutely no overtax attributed to them. 32 accused persons were sent to jail, my lord. I'm emphasizing 32 accused persons were sent to life imprisonment without even there is a finding that they have committed any overtime, assisted, insisted, surrounded, nothing. So lords may kindly see, therefore, Sarpanch Lunipata Gram Panchayat, fired from their guns towards the villagers. By such firing, these persons received injuries, my lord. Caused the injury to Vijay Dolai, Prasanta Raut, Indramani Swain was assaulted by means of a knife in the hands of Kedar Lenka. Other accused persons assaulted by means of lathi and threw stones pieces towards our. The injured persons were taken to Balugang Government Hospital. There, Samaraut, deceased, was declared dead. Mahendra Torey, Madhusudan Torey, Vijay Dolai, Dasarathi Raut, Kedara Lenka, Harihara Torey were also severely injured, were shifted to Brahmampur Hospital at about 9 a.m. The incident took place. So my humble submission before Lordship, my lord, why I am placing this FIR before your Lordship. In the FIR, my lord, 32 named accused persons, 50 named accused persons, and 65 others. 60 others, my lord. So 56 named accused persons, 60 others. And some of them, this Kulamani, my lord, has given the specific role that he has fired the deceased Samo as a result of his Samo died. Others have no role, my lord. I will come to 147, 140, I will come to my lord. 147, 140, applicability of 147, 140 to 149, I will come, my lord. But fact remains that one person's fired from his gun. That is the witness statement. That is the finding of the court. That was the charge also. Charge was, my lord, framed against two heads, my lord, two heads, my lord. Only to find out the school of money under section 302 and others also 302, 149 and other offences, my lord. So lordship may kindly see where the affair story is 56 named persons along with 60 others that will come with 100 plus, my lord, 113 or 114, my lord, 116. If all of them came there and out of them only 3 to 4 persons were armed with guns and some other persons were armed with lathis and tenta, and if they have assaulted, others having no overtake, not assisted, only because present, and the purpose, my lord, it cannot be inferred that they have come for an unlawful assembly. If unlawful assembly was there, my lord, all would have come with weapons. They were not armed with any weapons. Their only allegation against my lord, they are throwing brick bats. And interestingly, they were throwing brick bats, my lord. Those against whom specifically, although I am not conceding, my lord, before lordship for the time being, those against whom the specific allegations that those persons have assaulted. And although there is specific allegations against Kulamani, he had one person's died. And in absence of any material to show that others have any overt, my lord, by a single line, others are also brickbatting. So evasive a statement, my lord, others were also brickbatting. One single line has taken into consideration by the trial court and has sent, my lord, all these 32 accused persons to for life imprisonment. And your lordship will kindly see, on the basis of this FIR, my lord, charge was framed, which your lordship will find at page 133 of the paper book, my lord.
Yes, please.
Charge, my lord, page 133. Firstly, that you on about 23rd day of June 1990 at about 4 a.m. of a village.
9 a.m.
I'm sorry, 9 a.m. 9 a.m. at a village, Ghumusar Padar, in front of the house of Rajkishore Torei, did commit the murder intentionally, causing the death of by gunshot, and thereby committed offense punishable under section 302 IPC. So your lordship may kindly see Kulamani Naik. I am emphasizing Kulamani Naik, my lord, the principal accused. He has been named in the affair as the principal accused who has fired from his gun, as a result of which one deceased in this case, Samaraut, he died. And therefore, the trial court has framed rightly, I must say rightly framed charge against Kulamani, my lord, alone under section 302 IPC. Then your lordship may kindly you on or about the same day, time and place where illegal possession of guns, that is for 25 and 27, 25 Arms Act, my lord. And third is 27 Arms Act, my lord. So Kulamani was alone charged under section 302 IPC, my lord, for causing the death of a salmon. And my lord, others, so far the second charge, your lordship may kindly come to the next page, where 32 persons, that is again with Kulamani, they were charged, my lord. First, that you on or about 23rd day of June 1994 at 9 a.m., village of Ghumusarpur, in front of the house of Rajkishore Torei, where members of an unlawful assembly did the prosecution of the object of such assembly, commit the offense of rioting, being armed with deadly weapons. That is 148. I need not elaborate the charge, my lord. The second is, my lord, the second charge is that you on or about the same day, time, and place intentionally caused death of a Samaraut in prosecutions of the common object of an assembly, of unlawful assembly, which you are a member and thereby guilty of an offense punishable under section 302 by 149. So, my lord, he has charged section 302 IPC, my lord, alone against the principal accused, and also 302 by 149 against others. And then, my lord, to a number of accused persons, thirdly, I need not place the entire charge, my lord, unless it was to your lordship's valuable time, that is 307 by 149 against all the accused persons, my lord. Then the third, my lord, is the second, my lord, 25 Arms Act under read with section 149. And fifthly, 27 of the Arms Act read with section 149. My humble submission before lordship is, my lord, the admit some persons, my lord, I will also place before lordship, 3 to 4 persons who are armed with a gun. My lord, those who are armed with a firearm, my lord, they are Kulamani, number 1, Hajari Raut, number 2, I will prepare a chart and submit before lordship, Hajari Raut, my lord, who is appellant number 9, and Hajari Pradhan, who is appellant number 11, my lord, and Tukuna Naik and Jitendra, that they are appellant number 10, my lord. And so far Tukuna Naik is concerned, who is appellant number 10, my lord, absolutely there is no evidence that he has caused injury to anybody, my lord. And so far Kulomani is concerned, with the principal accused, my lord, by whose my lord firing the deceased dad, my lord. So far Hajari Raut and Hajari Pradhan are concerned, my lord, there are appellant number 9 and 11 respectively. That is, there's some simple injuries, my lord. That is PW 8 and 11. They have to have injured. This is the total injury, my lord, and so far the lathi is concerned. So far lathi injury is concerned, I prepared a chart, my lord. I will also prepare file subsequently, my lord. That is, my lord, 10 accused persons were armed with lathi. 10 accused persons are armed with lathi, my lord. So 10 who were armed with lathi, 4 were armed with the gun, my lord, and 3 were with the tenta, my lord. And so far others are concerned, they were brick batting. Brick batting is so unspecific, my lord. My humble submission is so unspecific. The rest of the accused persons, it is written in Odia, my lord. Rest of the accused persons who are brick batting, what does it mean, my lord? Rest of the accused persons, even admittedly that you are present, even admitted, and it cannot be said that they are an unlawful assembly. It cannot be said that they were the member of unlawful assembly, and thereafter the assembly became violent, and thereafter in persons to the common object of that assembly, they killed Kulomani. It cannot be said. Because the purpose is, my lord, to convey a meeting for settlement of a village dispute. So the assemblies can definitely not be unlawful, my lord. The Sarpanch has called. They have come. Now the inference he has done, if you have come to attend a meeting, why helmet, why firearms, my lord? But this real fact is, my lord, that first 3 persons have come to their village. That is in the evidence, my lord. 3 persons have come. They were returned. They were refused. They said, you come, call others. They were probably insulted or assaulted, for which, my lord, the other persons who came, they came to defend themselves. Yes, they are being attacked by the other villagers, because meeting was held in their village, my lord. It is not in our village. So apprehension, because of this enmity, apprehension is very natural. So apprehending, my lord, they have taken, not they, my lord, these 4 to 5 persons or 6 persons about whom I have placed with your lordship, my lord, apprehending arrest to them as a right private defense, my lord. They might have, those persons, not all, my lord, might have taken some arms. And my lord, at this spot, your lordship will find, that others, although are present, they have not participated. Except them, my lord, they have not assisted, abated, nothing. So, and the most important aspect, my lord, your lordship knows, my lord, your lordship is aware of, there are a number of decisions, my lord, to show that accused persons have also received injuries. In that case, in one occurrence, if the deceased died or some of the prosecution witness have received injuries, or one of them or 2 of them died, and the accused persons also received injuries, so it is the duty, bounden duty of the prosecution to explain the injury on the accused persons. Otherwise, the prosecution case will be suspicion. So non-explanation of injury it itself, my lord, speaks a volume against the prosecution, my lord. So, my lord, to that effect, my lord, there is a decision, my lord, and that is, that's a decision of Supreme Court, my lord, in the case of Lakshmi Singh and others versus State of Bihar, my lord. That is the important portions I am only placing, that is in paragraph 3, my lord, where their lordships have said, I am placing para 11 first, my lord. PW8, or SP Joyswal, who had examined Brahmadeva deceased and had conducted the postmortem of the deceased, had also examined the accused persons. Here, this is applicable to my case, my lord. The doctor who have examined the deceased, my lord, has also examined some of the accused persons, and their injury report has also been exhibited. That is on record, my lord, that is in paper book, that has come in evidence also. They have received injuries. The doctor has deposed, and their injury report has been marked as exhibit on behalf of the defense, my lord. So here, my lord, had also examined the accused Darshan Singh, who he identified in the court on April 22, 1966, and found the following injuries on his persons: bruise, 2 inside, 3 puncture. The size is mentioned, not very much essential, my lord. According to doctor, the injury number 1 is grievous in nature. I need not place what are the nature of the injury. But the important portions, my lord, towards the last, it is well settled that fouler the crime, this is the language, my lord, fouler the crime, higher the proof. Supreme Court has said long back, my lord, and the Honorable Court bench has also relied on that. You also said that fouler the crime, higher the proof. Hence, a murder case where the accused is proved to have sustained injuries in the course of the same occurrence, the non-explanation, it's very important, madam. The non-explanation of such injuries by the prosecution is manifest defect in the prosecution case and shows that the origin and genesis of the occurrence had been deliberately suppressed. So, my lord, here suppressed, which leads to the irresistible conclusion that the prosecution has not come out the true versions of the occurrence. This matter was argued before the High Court, and we are constrained to observe that the learned judge, without appreciating the ratio of this court in Mohorai versus State of Bihar, Manu, SC so and so, tried to brush it aside on the most unreasonable grounds by deciding a High Court judgment. The Supreme Court has observed that time and again we have held that the non-explanation of injury on the accused persons is a very serious lacuna in the prosecutions, and that should be taken into consideration while deciding an appeal either by the High Court or in the Supreme Court, since the High Court has not taken that into consideration, my lord, for which the Supreme Court has said, without appreciating the ratio, the High Court, without appreciating the ratio in the case of so and so. The question whether the investigating officer was informed about the injuries is wholly irrelevant to the issue, particularly when the very doctor who examined one of the deceased and the prosecution witness is a person who examined the appellants, Darshan Singh, and also in the case referred the above court, clearly observed as follows. Here, my lord, for taking a pause, my lord, your lordship will find that the doctor who has examined the deceased, my lord, widow 19, who has examined the deceased, my lord, he has also examined most of the witnesses, my lord, who has received on their persons. And my lord, that is also not, and that has been all these documents, my lord, has been exhibited by the defense through the very same doctor who has been examined as the prosecution witness to examine the postmortem report and the injuries, to prove the postmortem report and injuries found on the witnesses, on the prosecution party. So my humble submission, my lord, applying the ratio of this, my lord, admittedly, the accused and the accused side, the prosecution side, my lord, has received some injuries. Admittedly, they were examined by the government doctor, my lord. Admittedly, they had the reports, and those have been exhibited by the doctor in the court, and the Honorable Court has not taken that into consideration because no counter case was tried along with that case. That is not the ratio. Ratio is, my lord, the court has to find out. Because, my lord, if there is a free fight, both the side has received injuries, and the prosecution party, if are completely silent regarding how the other side causes, how the other side received injury, is it not a case, my lord, but the prosecution has not come up with a clean hand? Is it not a case, my lord, but the prosecution is suppressing an important aspect of this case? Is not a case, my lord, but the prosecution is telling half truth and half false, my lord. And once the witness is found to be unreliable by your lordship, once your lordship finds that, yes, this witness is not reliable, my lord, so how can your lordship rely on the evidence of the witness who has not spoken the whole truth, my lord, suppressed an important part of this prosecution case, suppressed the important fact that their side of that they have also caused the injury on the prosecution witness, my lord? How can they be relied? And on the basis of their statement, my lord, how 32 accused persons were sent to custody, my lord, for life imprisonment? This is the background of this case. So my respectful submission, my lord. Then, my lord, next observation, my lord, this court clearly points out that where the prosecution fails to explain But just what I have narrated, that again I found that is the language of the Supreme Court. This court clearly pointed out in a previous judgment, the Supreme Court said, and here the High Court has not appreciated, therefore the Supreme Court again repeated. This pointed out that where the prosecution fails to explain the injuries on the accused, two results follow. Number one, that the evidence of the prosecution witness is untrue. Directly covered case, my lord. We have received injuries. Our 10 accused persons have received injuries, not one or two. 10 accused persons have received injuries. The prosecution witness will remain silent as to how he received injury. Therefore, the Supreme Court has rightly said, what I was submitting before Lordship, I have not seen that there should not be believed. The Supreme Court has exactly said in the language, the accused, two results follow. Number one, that the evidence of the prosecution witness is untrue. Straight, my lord. The evidence, once the Supreme Court has said that the evidence of the prosecution witness is untrue, false. That means false, my lord. How the court has relied, and my most humble and respectful submission before Lordship, my lord, I am the highest court before the state. In view of these Supreme Court decisions, my lord, once the court hold that the injury, my lord, that the evidence of the prosecution witness is untrue, and second inference, my lord, the injury probabilities that the plea taken by the appellant, by that appellants. So the plea that we have taken, we have gone, and we have gone there, we have been attacked by them. This plea, my lord, rather it finds support from the fact that injury reporters are there. So then, my lord, and my lord, to this effect, another decision is, my lord, that is my 2010, volume 6, Supreme Court cases, page 519, my lord. And the party is, my lord, Eknath Ganapat versus State of Maharashtra. Here, my lord, I will place the relevant paragraph, my lord, paragraph 23. In our considered opinion, the aforesaid approach of the court below was incorrect. 9 persons, including 4 witnesses, belongs to the complainant party, received injuries. Here is an exact case. Either we have 10 persons in our case have received injuries, whereas as many as 14 accused persons received, 14 accused persons received injuries, including some who even suffered grievous injuries. Admittedly, there was a mob of about 75 to 100 persons. Exactly our case, my lord. We have a mob of more than 100 persons. This is the prosecution case. 100 persons have gone, my lord. 100 persons who decamped from the hillside to the place of occurrence by putting stones, and a melee followed. Melee means, my lord, your lordship knows that they went together being armed with stones. Rather, in this case, the common object or the unlawful assembly has some link, my lord, is found. There may be some evidence. But here, my lord, we have gone to attend a meeting and a melee followed. Not even a single witness, this is important, not even a single witness, including the injured witness, could specifically state as to who had caused which injury. This is important. Who has caused which injury, either to the deceased or to the injured witness or to the accused. But here is the difference is, the deceased was fired by Kulomani, all the witnesses have stated. Thereafter, my lord, 3 to 4 witnesses have stated regarding their own injury. Others have not received injury. And how others are responsible, no witness has said, except saying that they have come in along with others and throwing and brick batting. So, my lord, again surprised, my lord, the Learned Trial Court has failed to understand how the Learned Trial Court has gone to the extent to infer that those persons, 100 persons, near about 100 persons, of course, 32 has been charge sheeted, but the prosecution case is, my lord, as per the FIR, my lord, more than 100 persons. They came. 4 to 5 persons were armed with some lathi, etc., and 1 person's fired gun. And the others, my lord, one stray line, others were throwing brick bats. Brickbats means, my lord, small piece of brick. So somebody at the spot picked up a brick, even accepting, picked up a brick and throwing brickbats, my lord. That will also come within the purview of section 302 by 149, my lord. My respectful submission before lordship, it is too much, my 32 accused persons' family has been disturbed, my lord, 12 years of last, my lord, life imprisonment. Then, my lord, not even a single witness, including the injured witness, could specifically state as to who caused which injury, either to the deceased or to the injured witness or to the accused. A very general statement has been made out that the accused persons were armed with deadly weapons and caused injuries to the complainant party. In a situation where a mob of 75 to 100 persons entered into the class with the complainant party, it could not be been possible for any of the witnesses who would actually be concerned with their own safety and to save themselves from the assault to see that
Yes, sir. Correct.
my lord, to see would naturally be concerned with their own safety and to save themselves from the assault to see that as to who had identified what type of injury either on the deceased or on the injured witness. In view of such omnibus and vague statements, given by the witness, the court below acquitted as many as 21 accusations on the ground that there is no evidence on record to implicate them in the offense alleged. There being no other evidence to specifically ascribe any definite role to any of the 14 appellants, wherein it is difficult to specifically ascribe by any definite role to any of the accused persons. It is difficult to any of the deceased or the injured witness unless there is cogent and specific evidence attributing a specific role in the incident to the accused persons who have themselves been injured, and there being no explanation forthcoming as to such injuries. It would be unsafe. It would be unsafe to pass an order recording convictions and sentence against the appellants, more so when the prosecution has produced in support of its case witnesses who are inimical to the accused persons. Directly covers the present case, my lord. Then paragraph 26, it is an accepted proposition in case a group rivals and enmities, there is a general tendency to rope in as many persons as possible as having participated in the assault. So general tendency, my lord, admittedly there was a dispute between two villages. Admittedly, my lord, on that day, my lord, there was a meeting was proposed. So it is a general tendency, my lord, when there is a dispute between two villages, between two groups, the general tendency of the witness, my lord, to implicate as many more number of persons as possible. Paragraph 27, my lord, there is no doubt that the incident which happened on 12/9/2003 as an unfortunate incident in which two persons have lost their precious lives, not only the members of the complainant party received injuries, the members of the accused party also injured during the course of the incident, and some of the accused persons even sustained grievous injuries. A probe would prove to establish that the said fact on appreciations of the entire evidence on record, we cannot uphold the findings recorded by the High Court as also by the learned trial court. In our considered view, the aforesaid findings are against the basic canons of the evidence and the penal law. Consequently, we allow the appeals and set aside the orders of convictions and the sentence passed against the appellants, wherein
Tonight we hear the prosecution. Yes.
My lord.
We'll hear the other side. Yes.
Please, Lordship.
Plus, in this case, there are so many eyewitnesses. Like plus PW1, PW2, PW3, and PW5, PW6, PW8, PW9, PW10, PW11, PW12, PW13, and PW16. All are eyewitnesses to the occurrence. And out of them, there are 5 injured eyewitnesses. They were seriously injured in this incident. I'm reading the deposition of PW6 is quite clear, and clearly also any of the deposition of any of the eyewitnesses, okay, PW6, 8, 10, 11, 13, and others. Plus, you also find that they are consistent to show that there is common object on the part of this unlawful assembly form.
Masalti complied with.
Pardon?
There is a judgment called Masalti. That's the state of. Heard of it? Masalti.
Yes, Masalti. Yes.
And is that rule complied with, that each eyewitness should identify at least 2 persons? Every person must be identified by at least 2 persons.
My lord, here I am coming because they are known.
Free fight.
Free fight.
Yes.
So the rule is that one accused should be identified at least by 2 eyewitnesses. That is the rule.
My lord.
It's a thumb rule. It's a rule of precaution. It's not an absolute rule under the
rule of precaution.
Right. It's a rule of precaution. No, is that satisfied?
Yes, satisfied. Very satisfied.
All right. Let's examine. We'll examine it anyway. Yes. How do you explain the injuries? 2 points he has made.
Yes.
Injuries on the accused are not explained.
Yes.
2, he says that nobody says who injured which accused injured which witness.
Plus, there are so many persons involved in this crime. So many accused persons because there is a brickbatting between 2 villages.
No, but unless you tell us specifically, that's his case. He says unless you say A hit B or A and B hit C.
In such a crime loss, it is not possible to give a videographic presentation of the entire incident because they are known to each other.
No, then there will be exaggeration. So what he says by the last Supreme Court judgment,
yes,
once there is a previous enmity, 2 groups of villagers,
yes,
there will be a tendency just to exaggerate and say everybody.
Yes, there is a tendency. There I concede to that extent. There I concede. There some names may be introduced in this type of crimes, even if those persons are not there. But here, it is consistent evidence of PW. Plus, I am reading 2-3 depositions so that you will also get the point. PW 10. I am coming to PW 10.
Yes.
Is an injured eyewitness. I know the accused person in the dock. The occurrence took place 1 year and 7 months back on the day of Devasnan Purnima at about 9 a.m. on the village road in front of the house of Raju Tarai. I was present during the occurrence at the spot. First, the Sarpanch, Lingaraj Pradhan, was attacked by a lathi by Madhu Lenka. When some of us rushed towards him for the purpose of rescuing him, accused Kulamani Nayak, who was armed with a country-made gun, opened fire at Samsundar Raut. He received gunshot injuries and fell down on the ground. Thereafter, Hajari Raut, Chaitanya Nayak, and Hajari Pradhan fired their guns. Due to the gunshot of accused Hajari Raut, I was hit at various places on my body. The pellets hit me on my left side thigh, right hand, lower arm, anterior aspect, right side chest, 4 inches below the nipple, left leg, and right leg below the knee joint. The witness shows the scar marks at those places. Due to the pellet injuries on my body at various places, I sat down on the ground. I had not lost my consciousness by then. I have also seen accused Digambar Swami assaulting Bijoy Dalai by means of tenta. Thereafter, accused Jada Pradhan, Tirnath Raut, Surendra Raut, Pavitra Raut, Loknath Sahu, and Makadam Sahu assaulted me by lathi to various parts of my body. I sustained bleeding injuries on my left side arm and left side thigh. I also sustained injuries on my both the middle fingers right and left. Only thereafter I lost my consciousness. Thereafter I was shifted from Balugan to Barampur Medical College Hospital. I was treated as an indoor patient at Barampur for about 20 days. Plus, in the cross, that witness has stated is not a fact that the accused Hajay Raut had not opened fire at me, nor there any pellet injury on my body. Madhusudan Raut, Harihar Tarai, Dasarath Barik, etc. My village were standing close to me when I received gunshot injury. Tukuna, Hajay Raut and Hajay Pradhan opened fire in quick succession. They were at a distance of about 15 feet from me. I had received pellet injury at 7 to 8 places, and the pellets pierced through my body. At those places, 20 to 25 blows by lathi must have been given to me by the above-named persons on my left arm and left leg. I was not examined by the police at Baluga when I was admitted to primary health center. Police examined me after 1 month of my returning to my village from Barampur hospital. I have not disclosed about this incident to anyone else. The handle of the tenta with which Bijay Dole was attacked by Matia Naik is about 5 to 7 feet long. Accused Matia pierced the tenta to the chest of Bijay Dole from a distance of 5 feet, holding the same both the hands. It is not a fact that Bijay was not attacked. Accused Matia and Digambar by means of tenta. That none of the last, I'm coming to Bijay Dole statement last. Yes, I'm going to period 8 then. Let's PW8 at page 814. I know all the accused persons in the dock. The occurrence took place on 23rd June 1994, which was Devasnan Purnima day. The occurrence took place on the village road in front of the house of Raju Tarai of our village. It took place at about 9 a.m. I was sitting in the premises of our Jubak Sangh office prior to the occurrence. The Sarpanch Lingaraj Pradhan was also present with us for settling a dispute between our villagers and that of the villagers of Raghunathpur. There is a tank at a distance of about 200 feet from the Yuvak Sangh office. It is clearly visible from the premises of Yuvak Sangh office because 9 a.m. that was in the morning. While we were in the Yuvak Sangh office, 2 villagers of Raghunathpur came to the Yuvak Sangh office fast. They were Indramani Swai and Digambar Swai. The Sarpanch asked Indramani and Digambar as to why other representatives of their village had not come so far. On hearing this, Indramani and Digambar went back to call other representatives of their village. We waited for about 10 to 15 minutes, waiting for the arrival of the representatives of village Raghunathpur for an amicable settlement of the dispute. After waiting for 10 to 15 minutes, we saw a group of 50 to 60 persons coming in a body in an agitated and violent mood, armed with lathi, lethal weapons such as lathi, tenta, and firearm. They were also armed with brick bats.
One second, pause, my lord. 50 to 60 persons came, my lord, being armed. 32 persons have been convicted. And those about 50 to 60 persons came, this. Unspecific, the 32 persons also so and so unspecific.
Let him finish, sir.
Yes, I'm sorry. Only your lordship's query has not been answered by my friend, therefore.
Yes.
On seeing them, the Sarpanch went ahead of us to stop them at some distance to prevent breach of peace. The Sarpanch stopped the mob of village Raghunathpur consisting the accused persons in front of the house of Raju Tarai. 10 to 15 persons of our, including me, also followed the Sarpanch to the spot. No sooner did the Sarpanch made an attempt to stop the on-march of the accused persons and others. Accused Madhu Lenka dealt a lathi blow to his head, for which he fell down on the ground. Some of us who followed the Sarpanch to the spot rushed towards him to rescue him from being further assaulted. In the nick of the moment, accused Kulamani Naik, who was armed with a gun, fired a shot at the deceased Samasundar Raut. The gunshot hit him on the right side chest of the deceased. Due to the gunshot, the deceased fell down on the ground. Soon thereafter, accused Tukuna alias Jitendra, Hajari Raut and Hajari Pradhan, who were all armed with a gun, opened fire. The gunshot of Hajari Pradhan hit me on the left side chest, right side belly below the navel, and on the right leg, both above the knee joint as well as below the knee joint. 14 to 15 pellets hit me at different places of my body. The witness shows the scar marks. In fact, 5 pellets are still inside my body and the doctor advised against operating those places. I fell down on the ground due to the pellet injuries. Later, I came to know that Mahendra Tarai, Hariyar Tarai, Duma Barik and others were hit by the gunfire opened by Hajari Raut and Tukuna. When I was still lying on the ground, groaning in pain, I could Indramani's lathi blow to my left side ribs. Thereafter, I lost my consciousness. When I regained senses, I was at the Balogam PHC. I was also taken to Barampur Medical College for treatment. I was an indoor patient at Barampur Hospital for about 20 days. I was examined by the police after I returned from Barampur Medical College Hospital. I have not disclosed about this incident to anyone else prior to that. It is not a fact that I have not stated for the police that while we were sitting in the office of the Yuvak Sangh on the date of occurrence with the Sarpanch in our midst, accused Indramani Swami and Digambar Swami came to the Yuvak Sangh office. That Sarpanch, Indramani and Digambar asked to why other representatives of their village had not come so far. That on hearing this, Indramani and Digambar went back to call other representatives of their village and that we followed the Sarpanch up to the house of Raju Tarai. It is not a fact that I stated before the police that I am, along with my other co-villagers, went to the spot in front of the house of Raju Tarai after Sarpanch was assaulted by Madhulenka by a lathi. It is not a fact that I have not stated before police that Tukuna and Hajari Raut opened fire and that some of our villagers were hit by their gunshot. At about 11 am, we left Balogam PSC for treatment at Barampur. It is not a fact that I had no injury due to the pellets. I have no enmity with the doctor who treated me at the Balogam PSC. I do not know if any police officer accompanied us to Barampur Hospital. I have not seen any outsider present at the spot. It is not a fact that accused Kulamani and Hajar Pradhan had not opened fire at Samsundar Rao. It is not a fact that accused Indramani has not dealt a lathi blow to my left side ribs. It is not a fact that we have obtained a false certificate from Barampur Medical College Hospital with the help of police. It is not a fact that no occurrence took place in front of the
I don't have to read everything, so they're all negative suggestions. All right. It's okay. Every witness does not have to be read, sir.
Yes.
You put it in your written note of submission.
Yes. PW20 is the doctor who has conducted postmortem on the deceased loss. The Lordship will get it at case.
There's one injured, one deceased.
One deceased.
So that is homicidal by the blows. So that difficulty there, sir.
Yes.
And Kulamani is already dead, my lord.
Sorry? Kulamani is already dead. Correct.
Punished by the God.
Correct.
After long.
So the innocent person should not.
Mr. Nayak, that is the best argument so far.
He has been punished by the God. I should be punished by my Lord.
All right.
And PW21, PW18, 19, 21, all the doctors who have examined the injured witnesses. And PW21 is the doctor who was examined those witnesses who were severely injured and who have been shifted to MKC's Medical College. My place it no, sir.
Not necessary, sir.
All injuries are simple.
So it is not the case is that there is a meeting that goes without saying because in the 313 statement, all have stated that there is
those 2 points he made, you have to meet. He says witnesses are not clear who hit whom. Second and most important, injuries on the accused are not explained. He says, how can you have a prosecution case which does not reason the accused? Then how do you know who is the aggressor party, who is the victim party?
No, aggressor party is very clear from the evidence of the witnesses, injured eyewitnesses as well as the eyewitnesses, because those persons, 2 persons have come to the meeting. Then
suppose they came to the meeting for peace talks. No. You guys attacked. I mean, you meaning the prosecution party attacked. Why can't it be the other way around then? No, that the accused were the ones who were getting attacked and they defended themselves and one of the victim party got killed. No, that's the case he's trying to project.
No, that's case they have tried to project, and also that is the in that way in the statement record under 313 CRPC. But thing was they have come up in a group. A large group of persons have come to another village.
No, tell me, was there a cross FIR registered?
Yes, there is.
That is the answer, sir.
Yes.
Was there a cross FIR registered?
Yes, ma'am.
What happened in that counter case?
That has not been. Usually, when the law is tried together, But that what the IO has admitted, my lord, that there is a cross case. PW 25, my lord.
No, there is a cross affair.
What happened in that cross affair?
And there are also injury report marked.
That part was
That is also suppressed.
It's all a 30-year-old incident, sir. When 1996, 95, no, even earlier. When was the incident? 94. 28 years old incident. That affair can't be pending.
Okay.
Anyway, put it in your written notes. All right. Yes, Mr. Nayak.
My lord, your lordship has also already found that the query which your lordship raised has not been properly answered by the Learned State Council. So
right.
No, I can answer it.
And you have given the best answer so far. All right. We'll reserve orders. Both of you prepare notes. All right. Orders reserve notes of argument of both sides. 1 week, sir. All right. Thank you.
This time, my lord, I will not ask for time unless I am.
See, sometimes it's better not to keep asking for adjournment.
Your lordship probably has not mad. Most of my juniors are arguing matters, my lord, before lordship.
That is true. That is true. That is because we are not sparing them. It's good. Actually, more people should get trained by you. That will be better.
So I am obliged to your lordship because your lordship accommodate.
No.
It's good. Senior people like us.
No. That's the way juniors will come up. Yes.
Yes, I am diplomat.
Right.
Item number 84.
May I please, your lordship, kindly pray for Passover because.
All right. I think the one Supreme Court matter. Who is that? Supreme Court has fixed the time for disposal. Which is that matter? It's not there today.
My lord, that is item 89.
89. Let's deal with that. Where you are there in that?
Yes. I am for that.
89.
The state has filed for enhancement.
My lord. The case of the prosecution is that in this case, I have been the appellant has been convicted for 376 of IPC and for 302 for life imprisonment.
Right.
There is not a single eyewitness to the occurrence.
Rape? How will there be eyewitness, sir? Never heard of this. Yes.
So for the
it's all right. You argue. Yes.
And totally basing upon the circumstantial evidences, the appellant has been convicted. So far, the rape part of is concerned, there is no, doctor's opinion is that there is no sign of injury or symptoms of sex on the deceased.
All right.
Next to the prosecution case is that on the date of occurrence, that is on 11.
What is the age of the victim, sir?
That is 16 plus 17, my lord.
She was in 8th class.
8th class is one thing. Age is different.
Age.
That is 16 plus, my lord.
All right. So last scene, I'm sure there is one last scene evidence, sir.
Yes, so for the last scene, so for prosecution case is that on dated 11/5/2013, the girl was sleeping with her grandmother. In the mid of the night, the appellant who was in love with that girl called her and she went one that is stated as Kolaghara, that is a place where he made sex with that girl. When the girl stated for marriage, at that time the appellant poured kerosene on the victim and she caught fire. She created halla. On that point of time, 3 persons, 4, 5, and 6, stating that they had gone to out of their home to attend call of nature or urine. At that time, while they were opening the tap, they heard the shouting of the girl, and they went there to rescue her. At that time, the appellant was there and he ran away. No one has seen in this case that the appellant had called to the girl. No one has seen that the appellant has taken the victim to that Kalaghara, that house. Next to that, the prosecution case is that the incident took place inside that Kalaghar. But so far, the IO PW10 is concerned, that is not in the occurrence did not took place inside the Kalaghar but outside. And from that spot, no burning articles has been seized. Next to that, the prosecution case is that there was a dying declaration before PW was the doctor, and on the basis of that dying declaration and the evidence of 5, 6, and 4 who are the father and informant is the mother, that is PW1. On the basis of their statement, appellant has been convicted. So for dying declaration part is concerned, a dying declaration is not in proper form. That is not in question answer form. And so far, the first treatment has in one hospital from where the doctor has first attended to that victim, he has not been examined by the prosecution. Next to that, so far, while he was admitted in that first hospital, at that time, the mother of the victim, the deceased, has stated that the burning is due to self-immolation.
All right.
Then that so far PW7 is concerned, who is witness to the dying declaration, she has stated on her cross-examination that she was not present at the time of the dying declaration. Subsequently, on the next date, she has put her signature.
All right.
So, dying declaration should not be believed. That is not in question answer form. That has not been explained that everything else has been stated to the victim, whether the victim was in the fit state of mind. That has not been also written in the footnote of the dying declaration.
Yes.
And
so the PW8 is the one who recorded the dying declaration, sir.
Yes,
He has
he's
been
the
examined.
doctor.
He's the doctor who attended to her.
Yes, yes.
And
Not
the
PW7. Correct.
Postmortem report, the
Yes.
2 doctors are there.
So for PW8 is my lord concerned, I am placing his cross-examination. In regular course, a register is maintained with regard to allotment of duties to different shifts on different dates, from which the allotment duty can be ascertained. I have not admitted the victim, but she was admitted on 11/5/2012 at about 12 o'clock. I attended the victim at about 12:05 p.m. and the victim was admitted by Dr. B.N. Mishra. I have carried my treatment from 12 p.m. onwards, 11/5/2012 up to 9 p.m. in the night, and also resumed the treatment on the next day morning. My treatment continued up to 13/5/2012 till 12 o'clock. At the time of admission, the victim was conscious. Afterwards, regarding her conscious state of mind, the record is silent. Whether at the time of dying declaration the victim was conscious or not, that has not been stated.
All right.
My endorsement in the bedhead ticket also reflects that the patient was referred to SB Medical College, Kotak. When I visited the patient at about 12:05 p.m., she was in critical condition, having 95% bone injuries, and was beyond my control. she was referred to Kotak Medical. Though out of the treatment of the throughout the treatment, the mother of the patient was present by her side and expressed her inability to shift the patient to Kotak Hospital and preferred to treat at the headquarters hospital. Here my submission is, my lord, is that, so for dying declaration is concerned, mother from the beginning of the night till the medical, mother has never stated that my daughter has been poured kerosene by the appellant and that for is gone. Nowhere has stated. Rather, in the first hospital to which she had gone to for treatment, in that place she has stated, in PW1 has stated, that is that occurrence caused due to self-immolation.
All right.
I am placing the statement of next. I will place the statement of the PW1 also. Then I am coming the doctor's statement further. There is no such endorsement in the bedhead ticket that the fact that I have recorded the statement of the art conscious state. This is from the cross-examination of the doctor PW8 and was at fit state of mind. Next, I want to draw the attention of my lord to the cross-examination part of PW7, that is the witnesses to the dying declaration. And also the examination in chief, that on 11/5, that is Sasmita Mohanty.
She has turned hostile.
She has turned hostile. She has stated that she was not present.
All right.
From a hostile witness statement, relevant portion can be also taken. I was not on duty on the night of the alleged date. She has categorically stated. Cross-examination, I was never examined by the police. It is also a fact that I have stated before the police that Dr. Tripathi at about 9 p.m. in my presence, along with the presence of SI SK Tripathi, recorded the dying declaration of the deceased Gayatri Swine. Last para 4 race, she has stated, it is not a fact that I was present at the time of recording of dying declaration on record. Chintamani Tripathi, that the deceased has been ever dying declaration. And Dr. Chintamani Tripathi, it is not a fact that the deceased had given dying declaration in my presence and in my presence of the doctor. Further cross-examination, that is para 5. I was on duty on the alleged night. I have put my signature after the dying declaration was recorded by the doctor on the next date of the incident, when I resumed my duty in the morning on being asked by him.
Yes.
Then I want to draw the attention of my lord to the position of PW1, the informant, that is PW1.
PW1 is the mother.
Mother, my lord. She was thrown out with the girl till her death.
No, in the adjoining room, sir. She was not with the girl.
No, after the occurrence, she was my before that, she was sleeping with her grandmother. I am the informant in this case, and I know the accused person present in the dock. Deceased Bengoswai is my daughter. The occurrence took place in the month of May last year. On the alleged day of occurrence, when I was sleeping adjacent room along with my husband, deceased daughter was sleeping with my mother-in-law in another room. Dead hour of the night, at about 2 p.m., the accused entered into the house, called my daughter to took her away, allegedly plundered her chastity, and in the event of my daughter's persistence to marry her, the accused person denied, and when my daughter threatened his of exposing the same before her parents, family members, accused person brought the jerkin of kerosene available in the rice cellar of my nephew, Dibakar Swine, where the alleged occurrence took place, poured kerosene on her and fire on her person. When the daughter cried for help, on hearing and watching a file in the mill, Pavitra Swai at the spot, and by the time of their arrival, they saw accused Milu, alias Rasmiranjan Jena, fleeing away from the spot. Thereafter, I, along with my husband and other co-villager, arrived near the spot. By that time, rescued the daughter, half-burnt state there. She disclosed before me that the accused Rasmi Jana committed rape on her, and in her in insistence to marry, he refused. When she threatened him to divulge the same, he poured kerosene on her, fire on the body. Thereafter, immediately arranged one auto rickshaw and brought her to Kerodia PHC Public Health Center, who is referred to district headquarter DHH District Headquarter Hospital Puri. She remained in. Here, my submission is that the doctor of the Kerodia Hospital has not been examined by the prosecution, and the record from the Kerodia Hospital has not been called for by the prosecution.
All right.
Cross-examination. My mother-in-law is aged about 80 years. And my humble submission is that the grandmother who was sleeping with the victim, she was also not been examined by the prosecution. My mother-in-law has not been witnessed. My daughter, here in cross-examination, the mother is stating, my mother-in-law has not witnessed my daughter being called by the accused or taken by the accused. Prosecution case that the appellant called her and took her to that Kalagara. There he committed such and such things. No one has seen that the appellant has called her, or no one has seen.
No. How do you deal with PW5? Just come to PW5.
My lord.
I think your major, one of the main witnesses, PW5.
That is Pavitra Kumar Swai. He is also not the eyewitnesses.
What are you saying? Don't simply make that statement, sir. Please read that.
I know. Yes, I am placing that. I know the informant who is my grandmother and know the accused person. Deceased Gayatri Swai is my PUC aunt. The incident took place about 1.5 years back in the midnight at about 2 to 3 a.m. on the rice mill of Dibakar Swai. At the relevant time, I had a call of one lady person. On hearing the sound, I, along with Rinku Swai, rushed to the spot and found Gayatri in burning state and crying for help. And when we reached the doorstep of the rice huller, accused Milujana gave a push blow to me and escaped from the spot. Thereafter, leaving aside the accused person responding the demand of the situation, we immediately tried to save the life of the deceased and powered one. Thereafter, we shouted for help, and hearing halla, other family members, those who were living near, came near to the spot, and then we took aunt to our house. And by that time, she was in a conscious stage and disclosed before us that the Milujana called her in the dead hour of the night to the rice cellar, and there he committed rape on her, and on her insistence to marry her, to sprinkle kerosene on her body and set fire on her body. Thereafter, we took her to the hospital, one auto rickshaw, and she got admitted and finally succumbed to the burn injury nearly after 3 days of the admission. So for cross,
nothing has come in the cross, sir. Nothing.
When shouted for help, our family members and other para 5 I am placing, my lord, villagers, but I cannot name them personally. When we shouted for help, our family members and others, villagers gathered around, but I cannot name them personally because I was in a puzzled state of mind. Next, para 6, I cannot say what was the relation between the deceased with that of the accused. Very often, the deceased used to visit to the rice cellar for the purpose of milling paddy. Accused persons also visiting the mill in number of occasions. I have no knowledge regarding the development with regard to the relation of the accused with that of the deceased. My humble submission is that PW10, the IO, has stated that on the date of occurrence, there was a meeting between the family of the appellant and also the victim, not to the stating that the victim and the appellant not to meet each other because they were in deep love relations, and for which there was a meeting between them. The meeting of the victim with the appellant was not liked by their parents. That's why there was a meeting. My humble submission is that on that day of occurrence, whether while a PW1 in her statement at the time of admission in the medical has stated that she has self-emulated. My lord, I mean, pardon.
Carry on, carry on.
While mother has at the first instance has stated that she has and no one has seen that the appellant has poured kerosene upon her, and next to that IO, the PW10 also stated that the spot which has been described by the prosecution spot of occurrence, that is not the spot of occurrence. There is a contradiction. I am placing para 12 from the cross-examination of PW10. I have mentioned in my case diary that in between the family members of victim and accused in evening of 10/5/2012 with regard to their association. I have examined the participants of the meeting. It is not a fact that there was any conclusive decision in the alleged meeting wherein the victim was restricted to meet the accused. I have not mentioned in my spot map whether some black ening spice was on the ground where the deceased alleged to have been burnt. I have asked during my investigation how could the jerkin of kerosene came to the spot. It is not a fact that the report of the doctor by Exhibit 15 that no rape was constituted. It is not a fact that I have not seized the bedhead ticket of the because the bed ticket reveals the bone injury to the self-inflicted. It is not a fact the spot of the map that I have prepared is not the alleged spot of the victim was supposed to have been burnt alive, but the alleged spot is the house of the victim. I have not examined the grandmother of the victim with whom she slept on the night of the occurrence. Then para 10, I am placing from the cross-examination of the PW10. My, that is 8th, 9th line from the top. My CD also does not reveal the staff nurse Sasmita Mahanti was on duty or not. Earlier, I had stated that Sasmita Mahanti, the PW7, was not present at the time of dying declaration. I have not the bedhead ticket of the victim. I cannot assign any reason to that effect. At 9:15 p.m., I issued requisition to ADMO, District Headquarter Hospital, Puri, for medical examination of the victim, which was denied by the ADMO. Puri with this endorsement that the victim was in a state of morbid DT at 10 p.m. Though I have examined the victim on the same night, but I have not mentioned the time. But it was before 10:30, dying declaration was recorded at 9 p.m. As dying declaration by letter numbers 467 dated 12/5/2012, it is not a fact that the time recording of dying declaration, she was not a fit state of condition, where the doctor has himself stated that I have not stated whether she was in a fit state of condition or not. That is the PW8. So for medical examination rate part is concerned, the pathologist doctor has stated then I am placing the deposition of DW1, my lord. He is Badrinarayan Mishra. He is Dr. Badrinarayan Mishra. On 11/5/2012, at about 11:45 a.m., one Gayatri Swami, Hindu female so-and-so, who has been referred by CSC, Rebananwaga, by registration number 1409, dated 11/5/2012, brought to me for examination by her attendant while I was on duty as medical officer, OPD casualty, district head, DHH Puri. On examination, I found she's bone injury about 60%, which was later detected to be 95%. She was admitted to the female surgery ward for treatment by IPD number so and so on dated 11/5/2012. At the time of examination, whatever information was given by the attendants of the persons concerned was recorded in the IPD bed ticket. The burn might to have been caused at home by kerosene self-inflicted. The specialist requested to attend for person concerned. Exhibit 7 already marked is my report. Next is, in the case of 95% burn injury, it is apparently difficult on the part of a person to speak, and in general, in worst case, he cannot talk discriminately. The moribund condition of a patient depends upon the status of the person. Next, in para 3 cross-examination, at the time of admission, I have not mentioned in my bedhead ticket regarding the conscious or unconsciousness of the disease. I have not examined the total exact physical condition of the patient at the time of admission because was in very serious condition. My humble submission is that when a person has already gone for 95%, she cannot state dying declaration. And the footnote of the dying declaration, her signature or thumb impression should be there. While on persons, the postmortem doctor who has conducted the postmortem, he has stated that except the toe, all the 5% of the body of the victim was burnt. So how thumb impression could be put on the dying declaration? 78. So, yes. My lord was asking the questions regarding PW5. Yes. So, for my humble submission to that is that the witnesses PW5 and 6 have introduced a story that caused by giving a push to the escape the darkness, but none of the witnesses have seen the accused with the deceased before her death, which does not make out a case of last seen together and has been brought in evidence to show last seen incident. But PW2 has not supported the fact of PW5 and PW6. exhibition is the pathological report, which has been exhibited by IO, and the doctor is not examined. So the defense is deprived of cross-examining the pathologist in regard to Exhibit 15. The pathological report, there is nothing to suggest that there has been rape of the deceased before the death. But the prosecution avers that the rape cannot be ruled out, that the Modi's medical jurisprudence and medico-legal aspects of sexual defense say that physical verification as well as the presence of the spermata in the vaginal canal suggests rape. In Exhibit 15, it is clear that there is not any sign of rape in physical verification, and there has not been spermata in the vaginal canal of the deceased. So in this case, the question of rape does not arise. So far the rape part is concerned, this is my humble submission.
All right.
I have also certain decisions on the dying declaration where there is suspicion on dying declaration. There are some judgment also.
You put it in your notes, sir.
My lord?
You can put it in your note.
Yes, I can put it on my note. These are the judgments which I have. I want to cite it. I have also copied.
All right.
May I please, Your Lordship?
Yes.
Well, first and foremost, the age of the victim, as evident from the deposition of the doctor, my lord.
Yes.
Sorry, from the headmaster, my lord. He is PW3,
Yes.
Judicial Pradhan. The date of birth is 97, my lords. The date of birth is 23/1997.
Yes.
So at the time of occurrence, that is 2010, she was 13 years old, my lords.
Yes.
In my lord, I'll come to PW1, 2, 4, 5, 6. All other relatives who have, this is an incident which happens at the night, 3 a.m. in the night, my lord. Hearing the halla, the relatives, especially PW2, who is a cousin brother, and 5 and 6, they all rush to the spot. They have seen the accused fleeing from that area, and all of them are witness to the oral dying declaration. She has specifically said before all of them that I was called by the accused. After I came, he committed rape on me. And after committing rape, when I said that I will disclose it with the other family members, he poured kerosene on me and he left me. This is the consistent dying declaration before all the 5 family members, my lord. It's late in the night, 3 a.m. in the night, my lord. Definitely no other independent witnesses are there to. Then coming to the recorded dying declaration before the doctor, my lord. Like my learned friend was saying, let me take your lordship to PW8, who's a doctor. When and how the PW8 at page 64, it begins. Page, I'll not read the entire thing, my lord. Page 65, my lord, is important. Like he says, 65 from the beginning. I have not admitted the victim, but she was admitted on 11/5/2012. At about 12, I attended the victim at about 12:05 p.m. Just 5 minutes. Within 5 minutes, she has attended the victim. And the victim was admitted by Dr. B.N. Mishra. The fact that Dr. B.N. Mishra has not been examined is not of much importance, my lord, because this man, I have carried my treatment from 12:05 p.m. onwards on 11/5/2012 up to 9 p.m. in the night, and also resume my treatment on the next day morning. My treatment 13/5/2012 till 12 o'clock. At the time of admission, the victim was conscious. So, my lord, 12 o'clock, the victim is admitted. 12:05, this doctor has attended to her, and she has disclosed before it. And regarding, my lord, yes, my lord, it's true that she was 95% born, but that does not anyway deter from a person of making, because it all depends on the degree of burn also, my lord, and the places where she has been born, though that is not clear. But there are Katanoff decisions, my lord, which says that even if there is 95% burn, their dying declaration cannot be disbelieved only on that aspect, my lord. My lord, I'll also place some judgments regarding that, but my lord, I'll do that in my written note of submission. So, my lord, and as far as the nurse is concerned, my lord, she is stern hostile, but she does admit that she was present when she was admitted. So, this aspect, my lord, that this young girl at the age of 13 years who has been raped, and my lord, if I'll take your lordships to the IO's deposition, my lord, he says, I deposit a jerkin can. I'll take your lordship to that very limited portion, my lord, of the IO at page 69 of the para 4, my lords.
I seized one plastic jerry can.
Yes. Not only that, my lord, if your lordship will allow me, I'll read that at the spot on the same day, I seized one plastic jerry can containing a small quantity of kerosene, one red color bra, one half burnt brownish white cloth, one burnt matchstick in presence of witness Dibakar Swai and Bhajavan Pradhan. My lord, my intention of reading this, there was a clear scene of some kind of physical assault, physical activities, my lord, rather. And if we corroborate that with the oral dying declaration of the girl, my lord, she was subjected to rape, and after that she has been done away with by being poured on kerosene, my lord. Postmortem report also, if I take your lordship to the postmortem report, my lord. PW10 is the, PW9 is a doctor who was examination, my lord. I have mentioned in my report that it was a case of more than 95% burn injury. There was carbon particles in lungs, trachea, larynx, and bronchitis, which causes suffocation. I have not reflected in my report that there was no smell of kerosene from the dead body, which must not be present at the time of postmortem, nearly about 3 days. So, my lord, when there are oral dying declaration before the family members, and during the cross-examination, they have not been, there has been no scope to deny that, my lords. My lord, lordship, the mother also, my lord. If I'll take your lordship to the mother's deposition. Should I read it, madam?
Yes, please.
I am the informant in this case, and I the accused persons present in the dock. This is Benga Swine, is my daughter. The occurrence took place in the month of May last year. On the Alice date of occurrence, when I was sleeping in an adjacent room along with my husband, my deceased daughter was sleeping with my mother-in-law in another room. Dead hour of the night, about 2 p.m., the accused entered into the house, calls my daughter, took her away allegedly, plundered her. The event of my daughter's persistent to marry her, the accused person denied, and when my daughter threatened him of exposing the same before his parents and family members, the accused persons brought the jerkin of kerosene available in the rice cellar of my nephew, Dibakar Sai, where the alleged occurrence took place, poured kerosene on her and lit the fire on her person. When my daughter cried for help, on hearing the same and watching the fire in the mill, Pabitra Swai at the spot, and at the time of their arrival, they saw accused Milu, Rasmi Ranjan Jena, fleeing away from the spot. Thereafter, I, along with my husband and other co-villagers, arrived near the spot. By the time rescued my daughter in she disclosed before me that the accused Rasmi Jena committed rape on her, and in a resistance to marry her, she refused And when she threatened him to divulge the same, he poured kerosene on her, lit fire on her body. Thereafter, we immediately arranged an auto rickshaw and brought her to Keradia PHC, which referred to DHH Puri. She remained in the hospital for 3 days and subsequently succumbed to the injury on the alleged date of occurrence. And was my deceased daughter was 15 years old. I lost the FIR which scribed by my nephew for my instruction. After the same was read over and explained to me, I put my signature thereupon, which is marked at Exhibit 1. Cross-examination. My mother-in-law is aged about 8 years. My mother-in-law has not witnessed my daughter being called by the accused or taken by the accused. I or my husband also doesn't share the knowledge that the accused called and took my daughter about 2 p.m. on the alleged date of occurrence. And we discovered our daughter in the half-burnt stage in the mill. I have described all the matters before the admission of my daughter in the Puri hospital before the treating doctor and remained in the hospital throughout the treatment of my daughter in the hospital. With my mother, till she breathed her last. The accused, my daughter, were in friendly term with each other. The friendly relation of accused with my daughter was not viewed in good term by any of our family members. We have also restricted our daughter to develop her acquaintance with the accused persons. Still then, my daughter was maintaining the relationship with the accused persons. Thereafter, we have also restrained her not to develop the further tie with the accused person, and my daughter also agreed to the same. It is not in my knowledge that on dated 10/5/2012, my nephew Dibakar Swai detained the accused persons along with my daughter in his mill and called the parents and family members of both the accused and deceased. And one meeting was held wherein the accused begged apology before me, which was immediately before the incident. Pabitra Swai, Santosh Swai, and Mittu Swai are my grandsons, are the sons of my nephew. My house stands in between Mill House and Khamaradia. That I have stated before the IO. It is not a fact that I have stated before the IO that my daughter disclosed the fact before me regarding the alleged rape and getting fired on her body by the accused persons. I lost the FIR about 10 p.m. in the night but admitted my doctor at the DHH Puri at about 7 a.m. In the hospital, the treating doctor, while examining my daughter in critical condition, advised me to take her to Cuttack Medical, but due to financial crunch, I gave my writing response to the treating doctor for my refusal. It is not a fact that the accused was in love with my deceased daughter, and he has not committed rape and murder of my daughter. And it is also not a fact that my deceased daughter was minor at the time of the incident. My lord, why nothing has been.
All right.
So, my lord, why I read this portion is, my lord, the clear-cut motive also comes to the forefront, my lord.
Right.
That there was an earlier relationship, the boy was reprimanded for which, and definitely he nurtured a grudge against the family members as well as the girl because she agreed to her parents' decision of not meeting him and not keeping a relationship with him.
All right. I may be pardoned. I want to clarify to my learned friends' submissions. Earlier, my learned friend submitted that the 12 o'clock of night, she was admitted to the Puri hospital, and 12:05, she was at a fit condition. Doctor recorded the statement, that is PW9. From the statement which my learned friend read over from PW1, she has stated she was admitted to the Puri hospital, that is 7 a.m. Next to that, what my learned friend submitted that BN Misra was not been examined. I read over the DW1 statement, that is BN Misra, doctor of the first hospital, that is DW1 on 11th, Dr. Narayan Misra, on 11/5/2012 at 11:45 a.m., the Gayatri Swai Hindu female so on brought to me for examination of her attendant while I was on duty at as medical officer OPD casualty DHH Puri.
He has been examined as a defense witness.
Yes,
prosecution has not relied on him.
All right.
So the BN Misra has stated on examination I found she sustained burn injury about 60%, which was later detected to be 95%. My humble submission was that when a person has already burned 95%, is in a fit state of mind to give time.
There's no universal rule like that.
No. To that effect, I have also cited some judgments I have provided. I will also place that in my written note of submission. Next to that is that there is contradiction in the statement of the witnesses. So far, PW1 is concerned, and so far PW1, 2, 4, 5, and 6 are concerned. All are interested witnesses and relative witnesses.
Who else will come, sir, for a case?
So far, motive of the crime is concerned, of what my learned friend read over from the deposition of PW1. The girl was interested very much in love of that boy.
So don't deny that. I'm not denying that.
So my humble submission is that when the boy and the girl were in deep love, why the lover will pour kerosene upon the
She says in the dying declaration, sir. She gives you the answer for that. Yes.
No, so that dying declaration, my humble submission is that dying declaration is a created one.
I see. All these doctors and all sat down and
No,
stated.
only one doctor has stated where there is no, that is not in question answer form, where there is no.
So the doctor is interested in creating the dying declaration.
So why
must have a reasonable argument, sir.
Sir, the first
why should the doctor create a dying declaration?
So far the doctor part is concerned dying declaration. He has not stated whether the girl was in fit state of mind or not.
Right. He is the one who's recorded it. How will he not know? Yes.
Can I clarify one thing? Can I clarify?
Please. We are just in the midst of asking you a question. Don't interrupt, please.
My so far dying declarations in concern, I have cited certain judgments and given the copy to my lord.
All right.
That is one is 2011 SAR Criminal 972.
Yes.
That is Surinder Kumar versus State of Haryana.
Right.
Where a dying declaration is suspicious. Correct. It should not be acted upon without corroborative evidence.
All right.
Where a dying declaration is suspicious, it should not be acted upon without corroborative evidence. That is that distance. And another distance I have given. The last para of that judgment is para 17. Another judgment is, my lord, that is 2007 SAR Criminal 941.
Yes.
Dying declaration, suspicious one should not be acted upon. That is the nature of injuries here. Deceased was not in a position to make statement. Para 10, para 11, 12, 13. Dying declaration recorded by magistrate, credibility of medical evidence, impossible ocular version. Medical evidence cannot be ignored by placing exclusive reliance upon the testimony of person recording dying declaration.
All right.
Another judgment I am relying upon, that is 2009 SAR Criminal 677 Supreme Court. That is State of Rajasthan versus East. It cannot be formed the basis of conviction and cannot be acted upon. Prosecution case is that deceased husband poured kerosene oil on lit fire. Four dying declarations were recorded. In the statement recorded under 313 of CRPC, accused said the deceased father burnt her different, but in 313 here, in my case, I have completely denied. The appellant has denied regarding the occurrence and rape also.
It's all right, so we'll go through all of this. All right.
I may be permitted to give a written note of submission.
Yes.
I'll just submit one thing, my lord. Your lordship, there is 95% extensive burn injuries, my lord, but your lordship will appreciate that she has died of septicemia after 4 days.
All right.
Not 4 days after
2 days, but that means that by the time she was admitted, she was conscious, not in a very critical state to have survived for 3 days.
You say orders reserved. Both parties are permitted to file the written note of arguments within a week. It's call out and give a date.
Okay. Item number 84.
So we'll have it tomorrow, sir.
Supplementary list item number 85.
Next week, or at the request of counsel.
For the informant, my lord. Time and again, my lord, taking time, my lord, tomorrow, my lord.
Missed on
And my lord,
16th November.
Supplementary list item number 86.
in November.
Wait, please, ma'am. Devashish Panda.
Government appeal is also there, my lord.
17th November.
Supplementary list item 87.
87, my lord.
My lord,
My lord, I want BC, my lord.
86, my lords.
86 adjourned to 17th November. Item 87. Both the
23rd November.
87, your lordship, may be.
23rd November. Item 88.
88, my lord, I'm there for the appeal.
24th November.
Item number 90.
I beg your pardon?
24th.
lord, it's
24th
kindly
November.
recognized.
Item 90, sir.
My lord, it's kindly take up next week.
8th December.
Correct.